Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, January 27th, 2026. We have 11 bills on the docket today, followed by a voting session. We're going to start off with Senator Watson with Senate Bill 82. Then we're going to 67, 49, 202, 27, 81, 105, 107, 138, 230, and then we'll round out with 162 rather. So, Senator Watson, welcome back to JPR. The floor is yours.
Good morning, Chair Smith, Vice Chair Wald-Stryker, and committee members. Thank you for forcing me to shovel snow this morning and getting the ice up so that I could be here to testify first on time. I'm here to seek a favorable report on Senate Bill 82, a bill to include the creation of counterfeit leases and rental agreements as a felony under Maryland's criminal code. This bill is simple. It adds leases and rental agreements to the Criminal Code, Section 8, subsection 601, as a felony, which will finally allow the police, prosecutors, and the courts to penalize the fraudulent creation of leases and rental agreements to be jailed for longer than the current maximum of 90 days. Recently, Tamika Good, a squatter, was finally convicted of taking over a $2.3 million home in Bethesda. She was a squatter charged with multiple counts of burglary, trespassing, and other crimes. Last Thursday, January 22nd, she was found guilty on all charges of burglary and breaking and entering, but the courts were only allowed to sentence her to a maximum of 90 days in jail because it is not considered a felony, which carries a maximum of 10 years in prison for the fraudulent lease that she possessed. It took Ian Chin, a 19-year-old neighbor, to sue Tamika Good and bring her to justice because she disrupted the neighborhood, and some neighbors couldn't sleep for fear that criminals like Ms. Good would break into their homes and inhabit them as well. After spending more than 9 months in a multi-million-dollar home, the courts can only fine this squatter $500 and place her in jail for 90 days. This penalty is not sufficient deterrent to stop squatting because there's too much money made committing this crime. Currently, as some of you know, there are websites that sell squatting leases, and the website actually tells the customer that they will change the locks for them, and when the true owners come home, show the police the fake squatter lease and stay as long as possible to make the owners pay you to leave the property. This is a criminal network, and some of these squatters blackmail the owners and are paid upwards of $10,000 to leave because it's cheaper than hiring an attorney and waiting while they must pay their mortgage, insurance, and second residence to live in for a long time before getting their property back. We as legislators must address the squatting issue from different angles to ensure that our homeowners, our neighbors, and our communities are safe from criminal evasion. Senators, I ask you to vote favorable for Senate Bill 82. I have asked several homeowners whose homes or neighborhoods were taken over by squatters to speak today regarding this legislation. I don't know if Dr. Wang was able to get his testimony in, was he? Okay. He contacted me personally, and just a couple weeks ago. Dr. Wang is a professor at the University of Maryland Medical School who's in the process of selling his home, came home, and found squatters in the home. The fraudulent lease produced had the name of an active duty Navy person on there, which caused law enforcement and the judicial system to have to extend the time it would have taken to get the squatters out because they had to figure out the issues with the Navy person who was on there illegally. So this goes on. It goes on quite a bit. Some of you may know I've been working on other bills to try to help with squatting. Last year, we passed a squatters bill to speed up the wrongful detainer action, but it hasn't been enough. And so we want to really put pen to paper and hold those accountable who are providing these leases, facilitating this criminal network, allowing these folks to go in, break in properties, change the locks, and telling them that they can stay there as long as they want and somebody will pay for them to move out. That is that concludes my remarks for this bill, and I ask your favorable report.
Excellent. Thank you very much, Senator. We're going to hear from your virtual panel, and then we'll open it up for questions. So first up is Mr. Greenfield. Welcome.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. I certainly could have used Senator Watson to come shovel me out, but I appreciate the opportunity to testify virtually. Aaron Greenfield on behalf of the Maryland Multi-Housing Association here in strong support of Senate Bill 82. You have our written testimony. Rental fraud, as the Senator Watson mentioned, is widespread and growing. Since 2020, the Federal Trade Commission has received reports of nearly 65,000 rental scams with about 65 million in reported losses. National surveys have found that more than 5 million renters have lost money to rental fraud, with median losses around $400. Bad actors often use fake listings and fraudulent lease documents to elicit deposits and first month's rent for properties that either do not exist or which they have no authority to rent. Industry surveys show that 93.3% of property managers have experienced rental fraud, including falsified documentation such as income, identity, or lease terms. In many cases, fraudulent leases are paired with falsified supporting documents, so fraudsters can appear legitimate during initial tenant screenings. Victims of rental fraud often suffer significant economic harm, loss of security deposits, and may be left without housing, particularly harmful in tight housing markets like here in Maryland. Under existing Maryland law, general fraud statutes may cover misrepresentation and theft, but there is no standalone criminal prohibition tied specifically to the creation, dissemination, or possession of fraudulent lease or rental agreements intended to defraud. This bill fills this gap by creating a clear statutory offense focused on this behavior. For this reason and many more, MMHA requests a favorable report on Senate Bill 82.
Excellent. Thank you very much, Mr. Greenfield. All right. Is Edna Reynolds here?
Yes.
Welcome.
Yes.
You're up.
Hi, thank you. Good afternoon, Chairman and committee members. I appreciate this opportunity to provide this oral testimony in support of SB 82. My name, again, is Edna Reynolds, and I'm a resident of Prince George's County. And I'd like to acknowledge my neighbors because they are integral to my testimony, the Basses, the Platers, and the Baylors. As an individual who has been directly impacted by the challenges targeted by SB 82, I can personally attest that there's a necessity for this bill. Let me share the experiences that my neighbors and I had with someone using a fraudulent rental agreement to wreak havoc on the property owner from a financial perspective and emotionally traumatize us, the next door neighbors. In March of 2025, a house in our community was on the market, and it was commandeered by unauthorized occupants. When a real estate agent came to show the property, she was unable to access it because the lockbox had been cut off and the locks had been changed by the unauthorized occupant. The police were called, the owner was notified, and the police were told by the unoccupied resident or unoccupied person that they had a lease to the property. No paperwork was shown. It was a verbal assertion that they should be there. And to my knowledge, there was nothing tangible to support this, but they were told, the owner was told that he would have to handle this in the court. So suffice to say that in less than 24 hours, our lives had been turned upside down. We had to deal with loud parties, vehicles parked on the lawn, unleashed dogs, trash. It was just a nightmare for us. And fortunately, and I know a lot of people have endured unauthorized occupants in their neighborhood for years on end, but ours started in March of 2025 and it concluded the end of May. So I do support SB 82, and I hope that it will be favorably sent through the legislative process. Thank you.
Thank you very much, Ms. Reynolds. Thank you. All right. We'll turn it over to, is Dr. Wang in the room? Okay. If he arrives, Senator, we'll pipe his testimony in, but right now we'll turn it over to the committee for questions. I thought Senator James.
Thank you, Mr. Chairman, and thank you, Senator Watson. Is Senator Watson still here? Thank you so much for bringing this bill back again and for your presentation last year. Do you have any idea about why this kind of crime is escalating and where I'm leading? I'm open to any answer you have, but my thought was, and I hope this isn't true, that there isn't anything that legislatures have done when we're trying to help tenants and give tenants more rights and all that, which is a good thing. But, you know, for every good turn, you can have an exploitation of your good intentions. But I don't even know if that's driving it. So do you have any sense, if you talk to experts, they have some sense, seems like a contagion as well.
Well, my sense is, thank you for that,
Yes,
Senator. My sense is what it is not is an issue of affordable housing.
It's not.
It is
okay.
not an issue of affordable housing.
Okay.
It is a crime of convenience because folks have found a way to game the system. They found a way to make money, and once we stop this, they'll look for other ways to make money. It literally is a crime of convenience, and folks have found it to be profitable.
Right.
And because we have failed to do anything active about it, it has perpetuated, not just in Prince George's County, but also in Baltimore County as well.
Yeah, I saw recently on the news just an incredibly unbelievable case of this, you know, and you get your jaw drops. The ordinary person goes, how can you be doing this? How can you take over someone's house and then they're out renting somewhere else and can't get back in? But you may have misunderstood my question. It's okay if you don't know the answer. I just wanted to make sure that there wasn't anything the legislature had done. We have been working very hard to enhance protections for tenants, right? You know, giving them more opportunities to, you know, get caught up, more opportunities to go to court and forestall what they would consider an eviction that, you know, is wrongful or one that they want to remedy. Did you hear from anybody? And I don't know, maybe this might be better for the housing people, but yeah. I just want to make sure that we have not done anything that we could correct, and maybe this bill is the correction. We've done anything to make it a little easier for the bad guys and the exploiters to take something we intended for good purposes and are otherwise exploiting it. And that's why this has become so popular and widespread.
Thanks. Let me let Mr. Greenfield take a stab
and I
at
don't know
that.
if he knows either. Mr. Greenfield?
Yeah, I don't know that there's a direct correlation, Senator,
Okay,
between the tenant protections that the General Assembly has passed and this. I think Senator Watson is right. I think that this is a crime of convenience, and what's, I think, escalated it is probably technology. The fraudulent use of documents is very, very widespread with technology. But I don't know. It's a very interesting question, and I'd have to think about it and do a little bit of research and get back to you whether there is a correlation. But off the top of my head, I don't believe there is one.
Well, good. I'm relieved. I just wanted to make sure that it wasn't something glaring that you could point to. Thank you, Mr. Chairman.
All right, thank you very much, Senator Sidnor.
Thank you very much. Senator Watson, from listening to your testimony, to me it sounds as if you're not necessarily taking this legislation and aiming it towards people who are living within the property. Was I hearing you correct?
Can you restate that, please?
Sure. From your testimony, to me, it sounds as if the aim of this bill is going after the people who create the situation, not necessarily the people who use the lease and are the squatters themselves.
So I see I see the nuance you're trying to strike, right? On the first part, absolutely yes. We want to get those folks who create those leases and facilitate this. On the backside, I know there's been conversation with the Office of Public Defender about, well, what if I don't know that I have a fraudulent lease? What do I do then, right? And interestingly enough, what has been profiled on TV, these are folks who knew they had a fraudulent lease, who had went to this website with the assurance that they would be able to get cashed out and be able to move to other places. So what I think you're getting at is what OPD brought up. Maybe we need to tighten up the definition within the bill so that it is clear of what our intent is. But the person who holds the fraudulent lease can't just be allowed to stay there. Now, and I don't want to go off tangent. I've been working on another bill related to Maryland blockchain, which basically says if police officers can go into a recognized database, they see on record who the owner is, and it is not that person, and the owner is with that police officer, the officer should be able to take action immediately. That's the gold standard of what we need to do to protect property and property rights for owners. But I am open to any clarification that you may want to suggest. But this is something that I don't think this body can afford not to do something about.
And just so that I'm clear, I hear you. I'm not necessarily saying that I'm against what I believe you're trying to do. But you're right. I think the two unfavorables, and there was a letter of information that was talking about the broadness and the possibility because of the mere possession of, I guess, a counterfeit rental agreement or lease, that people who may have been duped could be brought into the criminal system unjustly. But I also hear what you're saying, which is for people who may have gone to these particular sites, you leave it to the state prosecutor to determine whether or not they knew or didn't know. Is that correct?
That's correct.
Thank you.
Thank you, Mr. Chairman. Thank you, Senator, for bringing the bill. As you know, I had a constituent, we've talked about this, who was posted abroad and then came home to a squatter in their home. And we've been dealing with this for a number of years. This is an isn't it so question, but I think we have to start talking about some of the premises that we've utilized here over the past few years and start to judge whether they are in fact true or not. And the previous discussion gets to that. The first is police are being trained that they have no power in these circumstances to make reasonable judgments based on their experience that anything that is real property, these are documents, go seek a judge, let the judge figure it out. But that doesn't happen in any other context. In other words, if I said my TV was stolen and my neighbor across the street took it, a police officer, and Senator Fulton can correct me, would go, and then if the TV was in the other person's house and said, hey, do you have a document for this to prove that you own this television, and they produced some kind of sketchy receipt, the police officer would have reasonable suspicion to believe that a crime had occurred, that something had been stolen, and maybe it was and maybe it wasn't, but the police officer is empowered to make judgments based on their experience to make that determination, and police are pretty good at that. And are they going to be right 100% of the time? Of course not. But we should defer to that expertise. And so my point is, one of the premises that we have here is that police officers can't make a judgment between what is a legitimate lease and what is not. And I'm starting to believe, after years of hearing bills on this, that that premise is no longer correct, that with proper training, police in other contexts make judgment calls all the time about what feels suspicious and what is not, and most likely could make those same determinations in this case, at least on a temporary basis, until something litigates out. And then the second thing was squinted out in the previous discussion, which is the idea that squatters are themselves victims. And we have utilized this premise for the past few years, that a lot of people who have fake leases don't realize that they have fake leases. And increasingly, based on what you described and what we hear from our community, I'm starting to doubt that premise as well, which is they may not know 100% that it's false, but if you go to a sketchy website and you download a sketchy document and you don't meet a human being that is the counter signature to that lease, there's good reason to believe that that lease is not legitimate. And so I guess I just want to express here, as we start to, we're probably in our 4th or 5th year dealing with squatting legislation, that our original premises that police can't make these judgment calls, that the squatters are themselves victims, may be less true than we originally imagined over the past few years. Isn't that so?
That's very interesting, but it is so. But it's not just, I just want to make it clear, you kind of make it sound like with the proper training, police could do it. I think with the proper tools, police can do it. There has to be a tool in place, and here's a gold standard. If I could pull up right now what the owner of record looks like and verify that that person is standing next to me, police can do that, then the police should be able to act on his word or her word that the person in their property should not be there and take immediate action. We need the tools to enable them to do that. Trying to show them what a real lease and a fraudulent lease looks like is a tough nut to crack because, as the senator said, technology is getting better and better. And we've always struggled as a legislature to keep up with advances in technology. He would be hard-pressed, he or she would be hard-pressed to discern the difference between a fake lease and a fraudulent lease, a fake rental agreement and a fraudulent rental agreement. And I've rented properties, been a renter for many, many years and signed rental agreements. Never once did it occur to me, maybe I should go to SDAT first, see who the owner is, and make sure that the rental agreement that I'm signing has the name of this current owner. We would not do that in the cause of just getting a lease signed or a rental agreement signed. So we have to really figure out what those tools are that can help facilitate this, in my opinion. And that's what I'm working on as well.
Thank you very much, and again, thank you for bringing this bill. It's really needed because we have many, many situations like this in our county and in my district. Just curious about something. As it moves from this, well, as it has been historically with this, there's generally a court process, right? There's a court process. Is it the person who is a false occupant of that house or the person who wrote the false lease? Are they to appear in court as well?
That's a great question, Senator Muse. I cannot answer that definitively. Not that I'm no longer an attorney because I'm no longer on this body,
right,
but I just can't answer that. I
Okay.
don't know how it would literally play out. And those are the nuances that I would hope this committee would help tease out. You know, if you feel the bill is as important as I do, what modifications can we make so that it's crystal clear who we're going after and in what circumstance?
And I'll stop. The reason I asked that is because I was just curious as to whether, if they were summoned to court, would any of them really have the nerve to show up in court? So I think I understand your question, and yes, we do need to do a lot of work on this. And again, thank you for that, and thank you, Mr. Chairman.
Thank you, Mr. Chair. So I'm looking at the bill, Senate Bill 82. It's got two operative paragraphs. One is paragraph A, and the other is paragraph B. Paragraph A refers to a person who, with intent to defraud another, it says, may not counterfeit, cause to be counterfeit, or willingly aid or assist in counterfeiting any lease or rental agreement. So that clearly is referring to the person who created the fraudulent lease. The only objection I find to that was one of the objectors said it's just described as lease or rental agreement. It could relate to car leases. So would you have a problem if we added to your language lease of real property, rental agreement relating to real property, to make it clear we're talking about real property leases and not car leases?
I have no problem with that at all, Senator.
Thank you. Then the second operative paragraph is paragraph B, which says a person may not knowingly, willfully, and with fraudulent intent possess one of these leases. Now that could also refer to the person who's physically present in the house. But the language that you have used is with fraudulent intent. So it seems to me that differentiates a person who totally innocently signs one of these leases and gets in the house, on the one hand, and a person who knows perfectly what's going on and with fraudulent intent possesses the house on the other. And your language only refers to the latter. Do you agree with me on that?
Yes.
So I have no problem at all with finding that that person is guilty of a misdemeanor, according to the language in your bill, and subject to imprisonment of up to 3 years or a fine of $1,000, because that person with fraudulent intent is occupying someone else's house.
And so someone without fraudulent intent who
Would not be
is in
covered by this
possession
bill.
of it would go through the normal court process.
Exactly. Thank you.
Given what my colleague just said, the fact of the matter, though, is either party would have to lawyer up. Am I correct?
If you're going to go to court, we always recommend to take an attorney with you. We've provided attorneys for tenants for a quite long time. We've done a lot to protect tenants. So I would hate for us to say, if they have to go to court and they have to get a tenant, that is something that would look negatively upon this bill.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you very much, Senator Watson.
Thank you, colleagues.
All right, with that, that'll conclude the hearing for Senate Bill 82. We'll now move on to Senate Bill 67. Senator Muse.
Thank you very much, and good afternoon, Chairman Smith and Vice Chair Wallstreicher and members of this great committee. For the record, I'm C. Anthony Muse, here in support of Senate Bill 67, relating to incompetency to stand trial. It's a bill that you've heard before, and we've been trying to move this bill along. I'm joined today by members of my panel, Tracy Varner from the Baltimore City State's Attorney's Office, who is here in person, along with Mr. Troy Turner, who you may remember, as he has been here for over the past several years to share his tragic history. As I said, Senate Bill 67 is not new to this committee. This legislation has been brought forward year after year, including by our former senator, Secretary, who is now Secretary Susan Lee. We worked diligently to move this bill out of committee in 2023 and 2024, and I'm here again because the issue it addresses remains unresolved and critically important. Under current law, charges must be dismissed after a set period of time when a defendant is found incompetent to stand trial. While that framework is necessary, the timelines were unintentionally altered in a way that no longer reflects the careful balance the General Assembly previously struck. Let me provide a little historical content here. Prior to 2012, defendants were charged with murder, faced a 10-year period before dismissal. The timeline was a product of extensive work groups involving public interest organizations, including the Public Defender's Office and the Maryland Disability Law Center. All agencies agreed that the 10-year dismissal period was appropriate for incompetent defendants charged with first-degree murder. All agencies agreed. Those discussions carefully balanced the rights of defendants with disabilities and the public interest in safety and justice. Here's what I'd say went wrong. In 2012, when the death penalty was repealed, the term capital case was removed from the statute. As a result, and without substantive discussion, not consideration of the consequences, the dismissal period for murder charges was inadvertently reduced from 10 years to 5 years. So Senate Bill 67 seeks to correct that unintended consequence. The bill restores the 10-year dismissal period for defendants charged with first-degree murder, and after careful consideration and balancing public safety and the defendant's rights, first-degree rape was added to this bill, as other victims in the rape case are vulnerable adults or children. It ensures that serious cases are given appropriate time while still respecting the constitutional protections for defendants found incompetent to stand trial. This bill also strengthens the procedural fairness by requiring courts to provide advance notice and an opportunity to be heard to the state's attorney and the victims of their representatives before a charge is dismissed. So Senate Bill 67 allows for victim and state participation. That ensures transparency. It makes sure that dismissals do not occur in isolation or without notice, and that victims and the state are given a voice before a final decision is made. I have proposed 2 amendments that I'd like to offer or to clarify, not change the substance of the bill. The first removes redundant language to avoid confusion while preserving all notice and hearing requirements. The second strikes the word charge to ensure there is no implication that the court's authority extends to sentencing for penalties. Both amendments are technical and improve clarity. In closing, Senate Bill 67 restores balance, improves the transparency, and corrects an unintended statutory change. It respects the right of defendants, acknowledges the interests of victims, and preserves judicial discretion. And so this year, I am going to continue to ask for a favorable report on Senate Bill 67 as amended. Thank you all. Thank you, colleagues, for listening. Okay.
Good afternoon. I'm Tracy Varda. I work as a prosecutor for Baltimore City. I've been handling our mental health court for the last 15 years, and because of that, I have firsthand experience that shows why this bill is so important for public safety. Currently, when an incompetent defendant is charged with first-degree murder or first-degree rape, the court is required to dismiss the charges after 5 years if that defendant is still incompetent. This bill allows additional time to treat and restore these defendants to competency so they may stand trial. What this bill won't do, it will not violate the constitutional rights of the defendants. Every 6 months, a defendant will be reevaluated, and if it's determined that they cannot become competent, the charges will be immediately dismissed. This bill allows the judge to dismiss the charges at any time. And this is a very narrow bill that will apply to a small population, but to an extremely dangerous population. What this bill will do, it will give the courts the option to hold the charges open for up to 10 years, but it will not require the courts to do so. And in order for the court to hold the charges open, the defendant must meet 3 criteria. 1, the defendant must be charged with first-degree murder or first-degree rape. 2nd, the defendant has to be found dangerous. And 3rd, the defendant's doctors must say that with additional time, this defendant is likely to become competent to stand trial. In a minority of cases, it can take over 5 years to restore a defendant to competency. This can happen because sometimes it takes a long time to find the right medication. Sometimes the defendant's on the right medication and then they just stop working, which is called breakthrough symptoms. And sometimes we have the defendants that don't cooperate with their treatment, and this prolongs the process. This bill will protect public safety, and especially for our most vulnerable citizens. In my experience, and mostly with the rape cases that I have, the vast majority of victims in these cases are either victims that have disabilities themselves or children because they are easy target. The last thing that I want to say is that I cannot, in under 2 minutes, express to you how important this bill is and all the reasons. For that reason, I have written there's some written testimony I've submitted, so I asked you to look at that. And for all these reasons, and on behalf of the Maryland States Attorneys Association, we urge a favorable report on Senate Bill 67. Thank you.
Excellent. Thank you very much. All right, we're going to hear from Mr. Turner first, and then we'll turn it over to the committee for questions. Mr. Turner, you're up. Welcome back.
Thank you for having me again. Hopefully for the last time. I mean, I'm not sure who's been here, who hasn't. Obviously, I can't see you guys, but just briefly, my story is my children's biological mother murdered them. They were 2 and 3 years old. Sarah and Jacob are the names. She was found incompetent to stand trial. She had been incompetent for over 10 years, actually. The charges were dropped against her because of the changes that have been spoken of. And when it happened, I had spoken of a fear that she would be out. I had spoken in front of you guys of that fear. And I was actually correct. Within 6 months, she was originally let out and allowed to go from her commitment being mandatory to it being voluntary. And she opted to come out into a group home. She requested to go back due to anxiety and then was fully released within 3 years later, as predicted. When she was fully released, there was zero, there was nothing there that said she had to remain on medication. She was found to be, at the time, released and not dangerous, and then was deemed dangerous whenever we went back into court. She was released into a small community on the Eastern Shore where there were a lot of families with small children and a lot of elderly people who were retired, and nobody was even notified. It was all over the media where these people were coming out talking about how mortified they were whenever she was arrested and they found out. The quote was from an elderly lady that they had released a monster into their community and never informed them. Basically, this will take away the secondary gain of just counting days until 5 years. This change will do a lot of good in terms of public safety, and also it gives people who actually do want the help and need the help time to receive it. One of the things that we've heard over and over again is that, after X amount of time, then someone's not going to be competent. It's just been proven wrong. 11 and a half years later, she was found competent, and it was due to the rearrest and her choosing to accept what would make her competent and help her get better to be there. I just want to thank you guys for listening to me again. It's been 8 long years, and please do the right thing and fix this.
Mr. Turner, thank you very much for your testimony, and thank you for your continued advocacy. It's good to see you again.
Thank you.
We're going to turn it over to the committee for questions. Okay, seeing none, thank you all very much. Thank you. With that, that will end the testimony for the proponents of the bill. We'll now switch to the opposition panel. I know Ms. Watts is joining us virtually, and then Ms. Parsley, come on up if you are here. Okay. Is Ms. Watts in the waiting room? Yep. There. Ms. Watts, you're up. Welcome.
Welcome. Thank you. Chair Smith, Senator Waldstreicher, and committee members, we thank you for hearing us today. Certainly, situations like Mr. Turner's are among the most agonizing ones we can imagine. And of course, all of our hearts break for him. But that doesn't change our bedrock principles in lawmaking, and those are the U.S. Constitution and Maryland Declaration of Rights. Let me first say, just because I don't know how much all of you know about competency to stand trial, but it's actually a fairly low bar. It requires only that a person be able to understand the nature of the proceedings and that their trial rights in a rational way, and that they be able to assist in their defense. Very often, being able to correctly state the roles of judges and attorneys is sufficient. It doesn't require people to be able to make smart decisions, just to be able to talk to me and assist in their defense. people charged with criminal offenses and found incompetent are either so mentally ill or so intellectually disabled that they aren't competent to stand trial, and they cannot be held for a more reasonable amount of time than necessary to restore them to competency or to determine whether they will become competent. That is a constitutional principle. Commitment to a hospital must be tied to the goal of restoring competency. The expansion of the dismissal time from 5 to 10 years for rape and murder isn't tying it to that goal, but rather to the nature of the charge. Our current timeframes are reasonable. The vast majority of people will become competent in those timeframes. If they are released, it is already the law, as Mr. Turner mentioned, that if a prosecutor has reason to believe that a person has attained competency, they can refile those charges because that dismissal is without prejudice. We are most concerned about the provision allowing prosecutors to petition to extend time for the dismissal at any time. We believe it's unconstitutionally vague because it sets no standards for when prosecutors can file. We therefore ask for an unfavorable report.
Excellent. Thank you very much. Ms. Parsley, you're up. Welcome.
Welcome. Good afternoon. Lucienne Parsley. I'm Litigation Director at Disability Rights Maryland. We're the Protection and Advocacy Center for Persons with Disabilities for this state, and here to express our concerns about Senate Bill 67. I want to be clear, just for everyone, that someone who is found not restorable to competency and has their charges dismissed is not released to the community. They are then can be involuntarily committed if they're found to be dangerous. And that is typically what happens. And then they stay there for usually quite a long time because our state hospitals are extremely conservative about releasing people to the community. The purpose, as Ms. Watts said, is of our incompetency laws are to provide restoration services to allow someone to become competent to stand trial. The weight of the social science research, there's so many studies on this, show that the vast majority of people are found competent. In fact, the most recent meta study I just looked at found that 80% of people were restored to competency within 90 to 120 days. So expanding on the amount of time that people have charges pending is going to really result in people remaining in the hospitals for the longest period of time because they are so conservative, and people who have IST charges typically remain for the longest period allowed by law. This means they don't get a lot of services in the state hospitals. They get competency restoration services. They are held on the very lowest levels. They're not allowed to progress through the level system. They don't typically get individual therapy. They're kind of in a holding pattern. So they are not getting robust mental health treatment. It's going to result, just in people remaining in the hospital. We already have a whole 200 people waiting in our detention centers under very significant, hard circumstances. And this is going to extend that problem. Thank you.
Excellent. Thank you very much, Ms. Parsley. Questions from the committee? All right, seeing none, thank you all very much. That'll conclude the hearing for Senate Bill 67. We'll now move on to Senate Bill 49. Senator Muse.
Again, good afternoon, Mr. Chairman and Vice Chairman, members of this committee. For the record, I'm C. Anthony Muse, representing the 26th Legislative District of Prince George's County. I have with me, if they can come up, also a panel that includes Eric Tars and Kevin Lindemood. If they're here, they can come up. If not, I'll take their time. Senate Bill 49 was introduced, we dealt with it last year. It would protect unhoused individuals from criminalization for basic survival activities such as sitting, sleeping, eating, and protecting themselves in public places. This is dear to me because, as many of you know, I spent a lot of my childhood living on the streets. And as such, as the laws are currently written, I would have been accused at any point of any one of these infractions that I've just read out to you. As you know, criminalizing homelessness does not address the root cause and only perpetuates hardship. In fact, it adds to the burden on the state and communities. It is both immoral and counterproductive to punish people for simply existing in public places while they are denied access to adequate housing. Maryland faces a severe shortage of affordable housing. The lack of shelter spaces for individuals, especially vulnerable groups, to make unsafe choices, escalating risk to their physical safety and well-being. I'll let, if they're still here, or maybe they are here, okay, I see them now. I'll let them address the specific statistics of this shortage and its effects. Vulnerable communities, such as Black and brown people, victims of domestic violence, face an increased risk of homelessness. We also see a large number of our brave veterans finding themselves unhoused after serving our country. I think that is horrible and disgraceful. And let's be clear, housing should be a fundamental human right, not only in the world, but at least here in the United States of America. And in reality, it is not. By offering these protections, Maryland would join other states like California and Oregon, which have passed similar laws to ensure that people without homes are not unfairly penalized for merely trying to survive. Let me offer a brief explanation of the proposed amendments. The First Amendment strikes the mention of certain categories of minors in the definition of unhoused individual. This change was requested following conversations with the Coalition to Protect Maryland's Children. They felt that by explicitly mentioning minors abandoned in hospitals and minors waiting for foster care, the previous language would unintentionally restrict the rights of other category of minors. Mine was simply when my parents just left me abandoned in the streets. The Second Amendment was done following conversations with SHA and MDOT. It offers clarification that an unhoused individual may occupy a vehicle only if it does not obstruct traffic or create a hazard to others. The clarification reinforces that public safety and traffic enforcement remain fully intact. It ensures the bill protects survival without creating exemptions from safety laws. It protects people using a vehicle as temporary shelter while preserving law enforcement's authority to address unsafe or obstructive situations. In closing, SB 49 is an important step toward a more compassionate and just society, as well as toward practical solutions for homelessness. Therefore, Mr. Chairman and members, I really would like to urge a favorable report on this very important bill.
Excellent. Thank you very much, Senator. All right, we'll now switch to the proponents of the bill. We'll hear from Eric Tars first.
Thank you, Senator Muse and members of the committee. I'm Eric Tars, Senior Policy Director at the National Homelessness Law Center, and I helped to draft the model that SB 49 was drawn from in the wake of the awful 2024 Supreme Court decision in Johnson versus Grants Pass, where the court decided that cities can ticket or arrest unhoused people for simply trying to sleep and keep themselves warm outside, even when they have nowhere else to go. Since that case, more than 300 cities, counties, and states have done just that, including 2 here in Maryland. We testified to this committee last year, warning that this bill was crucial to protecting Maryland's unhoused residents from President Trump's threats of a national camping ban and putting homeless people into government-run detention camps under threat of arrest. A year later, these threats have turned into reality, as President Trump ordered federal law enforcement to demolish homeless encampments and threaten unhoused people with arrest in D.C., and used executive orders and funding restrictions to try to force these approaches on communities nationwide. The legislation before you today is vitally important to restore the protections Lawson grants pass and help ensure Maryland residents who can't afford the rent don't end up in one of Trump's homeless detention camps. Communities in the Ninth Circuit and across the country have lived with similar laws for years and successfully reduced encampments. Under this law, Maryland communities are still free to respond to encampments with any of the many more effective methods than trying to arrest and ticket people. They can still enforce anti-camping laws if they provide shelter alternatives, and they can still arrest homeless people for violating other laws. Polling shows that 3/4 of Americans support the simple principle set forth in this legislation, that communities should not be able to arrest Maryland residents who can't afford the rent just for the act of trying to sleep or shelter themselves from the cold, rain, or heat, without at least having to first make sure they do have a place to do those things. We all win when we solve homelessness. Not arresting or ticketing people for sleeping outside when they have nowhere else to go is a vital first step. More must be done, but by passing SB 49, Maryland can show that housing is a solution to homelessness, not handcuffs. Thank you.
Excellent. Thank you very much. All right, we'll now move on to Mr. Lindemood. Welcome.
Thank you. Good afternoon, Mr. Chairman, members of the committee. I appreciate the opportunity to testify. My name is Kevin Lindemood. I'm the president and CEO of Healthcare for the Homeless. We are Maryland's leading provider of integrated health services and supportive housing for people experiencing homelessness. We served a little more than 11,000 different people last year in Baltimore City and Baltimore County, and we're here in very strong support of SB 49. Over the past 40 years, we've come to understand homelessness as primarily a symptom of poverty and the lack of affordable housing. Housing costs are growing at 2 to 3 times the rate of income. And a recent report by the Government Accountability Office has found that for every $100 increase in median rent, homelessness goes up by 9%. I started my career 30 years ago as an outreach worker, and I can tell you from experience that the forced closure of encampments, the issuing of citations, is cruel, costly, and frankly, utterly counterproductive. No one wants homelessness, least of all those experiencing it. Today, our mobile clinic and street medicine teams engage people where they are, under bridges, on park benches, in the doorways of businesses. We know that effectively creating trusting relationships can take months or even years. And those relationships, unfortunately, can be damaged within minutes with arrests, citations, and encampment sweeps. Over the past 4 days, we've seen Maryland communities respond with great compassion by creating emergency overflow shelters to keep people from freezing to death. Our street medicine folks are on the streets right now, partnering with the city, encouraging people to move into shelter. The Supreme Court has given communities more incentive to further criminalize homelessness. Instead of this ineffective cruelty, let's ensure that Maryland responds with compassion at any time of year. Thank you for the opportunity to testify.
Excellent. Well, thank you very much. All right, we'll turn to the committee for questions for the proponents of the bill. Senator West.
Thank you, Mr. Chair. I guess I should talk to the sponsor of the bill. Could you go back to the podium?
Sure. Yeah, I'll allow that.
Thank you. So I'm just looking at section 3-2704, and it can be read in isolation from the rest of the bill, and that's the way I read it. It says, this section applies to a prosecution for criminal trespass under various other sections of the criminal law article, or disturbing the peace or disorderly conduct, again, under a different section of the criminal law article. And it says, in a prosecution for an offense listed in subsection A, which I just referred to, a defendant may assert an affirmative defense of necessity if the defendant committed the alleged criminal act while engaging in a life-sustaining activity. So my question is, if someone breaks into a house which is unoccupied because the residents are away and occupies that house as a squatter because it's cold outside, and the person uses and claims that they're engaged in a life-sustaining activity, doesn't your language say that that would be an adequate defense for a prosecution against that person for criminal trespass on that private property?
I don't think so. I think that, and just in jest, that Senator Watson's bill kind of handles that a little bit more than this one. I am not sure that, and I'll have to ask and get that back to you, but I wouldn't think so.
Okay, well, I'm just looking at
It talks about public. Go ahead.
The other parts of the bill talk about public property,
right.
but not section 3-2704. And maybe the lawyer
Yeah, I see
on the
someone
line,
wants to answer it there.
I couldn't get your last name, Eric.
Eric.
Maybe you could answer this question better because you're a lawyer, I assume.
Yes.
So could you focus on section 3-2704? It appears to me if somebody claiming that they're engaging in a life-sustaining activity breaks into someone else's house when they're not there and occupies that house and stays there in that house as a squatter, section 3-2704, once that person is arrested for criminal trespass, gives that person a defense because the person broke into the house while engaging in a life-sustaining activity. That's how I read it. Do you read it differently?
I do read it differently because the law explicitly only applies to public lands. So if there's trespass on public lands, then that would apply, but it would not apply to private property.
Well, I'm looking at section 3-2704. Can you refer me to the section, the portion of that which limits the applicability of this to public lands? I don't see it.
Are you asking Eric or are you asking?
I'm asking the lawyer.
I agree. I don't see it there. The bill was, as this bill was being adapted from kind of our template legislation to the Maryland legislation, they tried to fill in these specific Maryland sections of law, and I think in doing so, that may have been inadvertently done. But I mean, the intent was for this to apply only to public lands, not to private dwellings.
Great. Well, I really appreciate your honest answer. Last week, I had trouble getting answers from a witness. I like talking to witnesses who give responsive answers. So would you have a problem if we were to amend section 3-2704 in order to make it quite clear that this would only apply to public lands and would not apply to private property?
I mean, I'm not the bill sponsor, but certainly that was the original intent as we had brought it to the bill sponsors.
Okay, thank you very much.
I have no problem with that. Thank you.
All right.
I'll allow it.
Further questions from the committee? All right, thank you all very much. That'll conclude testimony for the proponents of the bill. For the proponents of the bill, we'll now switch to the opposition panel, and we'll hear from Mr. Castelli and Ms. Sample. Ms. Sample, you're up.
Hello. Can you hear me all right?
Yes, we can.
Wonderful. Thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I am here on behalf of the Maryland Association of Counties, and we are here in respectful opposition to Senate Bill 49. I've gotten a lot of feedback from our members on this, so please bear with me. I'm going to go ahead and bullet our major concerns for the sake of your time. There's 5 of them. It preempts local authority and discretion in these interactions. It creates a new cause of action against local governments. It significantly increases liability. It increases the risk to community health and safety, and increases operating costs to manage those threats. I know that was a mouthful. Another major concern was the logistics of how this would be implemented. I'm not going to bullet all of the logistical issues and hypotheticals because there were far too many. But I think the main takeaway from that feedback is the reality that a local official, even in attempting to comply with the law, could unknowingly violate the rights of an individual as they're outlined in the bill. And that's where you see that spike in liability and premiums and things that we're concerned about because of the misinterpretation of some of the language. And the last thing I would say is just from a county perspective on just context here, following the grant pass Supreme Court ruling, we don't have, and I've looked and I've touched base with our jurisdictions, we don't have evidence that broadly our jurisdictions are abandoning their current careful and considerate strategies, I would say. And we're not seeing that they're taking a heavy-handed approach on removals or fines and arrests. And we know that that's just not useful. We know that that is a kind of a strategy that would break trust and ultimately make the situation worse. And just like last year, we are happy to continue to work with the bill sponsors, even in our position of opposition. And as long as there are individuals unhoused, there's certainly more that everyone can be doing. And we're not saying that there isn't more we could be doing. We're just concerned that this isn't the way to do it. So we do urge an unfavorable report on Senate Bill 49. Thank you so much.
Thank you, Mr. Chair. Bill Castelli with on behalf of the Maryland Realtors. And we are also opposed to the legislation. We think the clarification that you made about public property and that this applies to public property would alleviate a lot of the concerns that we have. It's just, if you take a look at the language and the way it's described, it talks about public property that is owned or leased in whole or in part by the state or local government. So we do wonder about private property where you do have leases that the government may be there. You might have government programs. In fact, many apartment buildings might have contracts with the federal government, as well as with state and county agencies as well. So does that capture them in terms of this, where it would theoretically capture those private property? So those are kinds of the concerns that we have over the specific language in the bill. And we think that the bill should be, we think there are better ways to target assistance to homeless rather than trying to potentially impact private property and deputize, those private institutions. And for those reasons, we would encourage an unfavorable report.
Thank you very much, and thank you for your thoughtfulness on this. Are there any amendments that you all can or are prepared to make that will make this bill more amenable to your concerns so that we can move on with the bill?
I think we could give you some language that we think would strengthen the concerns that we have on private property. Absolutely.
That would help. And Sarah, I know we say, I'd like to spend another year studying this, but I don't know how much more we can add on to it because we've already had study groups and study groups and study groups. So if there's some amendment that you think would make this bill more palatable, then I'd be more than glad to, we would be more than glad to look at that and to work it out.
Wonderful. Thank you. I appreciate that.
Thank you. And thank you so much, my friend. And thank you.
Excellent. Further questions for the opposition panel? Okay, seeing none. Thank you very much. Thanks.
Thank you.
All right, with that, that will conclude the hearing for Senate Bill 49. We'll now move on to Senator Folden with Senate Bill 202.
Wait, 202? Oh, yeah. Okay. Come up, panel, come up. Yeah, Chair. Mr. Chairman, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings, for the record, William Folden, State Senator for District 4. Before you today is SB 202, dealing with police discipline in order to show cause. This bill comes from the idea that we have certain laws that have been enacted regarding relative to police accountability and discipline. And we have at times an issue with getting that transparency from the agency so that the officer is not put in a holding pattern, but that they're given reason and justification from the agency to show cause why certain actions are taken against that officer. So with that, I would like to have my panel and just kind of go into further details about that. But we would be asking that this show cause be an important and additional step in the MPAA to allow the officers to have the opportunity to have the agency show cause as to why certain policies are being handed down or certain disciplines are being handed down, and it's relative to discipline. So with that, I would ask for a favorable report of SB 202.
Good afternoon. My name is Michael Davey. I am General Counsel to the Maryland State Fraternal Order of Police, and the FOP is requesting a favorable report on Senate Bill 202. The passage of this bill would allow a law enforcement officer who's been administratively charged by a law enforcement agency or an administrative charging committee or believes that a right under the Maryland Police Accountability Act has been violated to go and apply to the circuit court in the county in which they're employed and direct that law enforcement agency to show cause as to why that right under the Police Accountability Act was not granted. This bill would allow a law enforcement officer to file the petition to show cause in the county in which the officer is employed prior to the start of any hearing. This action would require a law enforcement agency to explain to the court why a right or provision of the Maryland Police Accountability Act was not granted or a provision was not followed. The purpose of this bill is judicial economy. If the circuit court judge agrees with the law enforcement officer and his right or provision of the Police Accountability Act was not followed, the judge would have the ability to order the appropriate remedy. A remedy would likely prevent a law enforcement agency from conducting a hearing or having to conduct a second hearing on the same investigation. There are certain aspects of the Police Accountability Act that an administrative law judge or a retired judge sitting before a trial board does not have the authority to intervene. Some of those things are discipline being given to the law enforcement officer prior to a hearing, and it's happened. Certain constitutional issues, investigations that were or were not reviewed by the ACC that should have been, assistance of representation, issues involving emergency suspension, whistleblower violations, secondary employment violations. A lot of those don't even involve discipline, but there is no avenue to get a court to intervene without having a show cause or a manner to get in there. The only way to do it now is file a motion to stay or a writ of mandamus, which is taking months to get before the court. This would speed up the process much faster. We would request a favorable report on Senate Bill 202. Thank you.
Good afternoon. I'm Mike Shire on behalf of the Maryland Fraternal Order of Police and the Anne Arundel County Lodge 70 Fraternal Order of Police. As was stated, this bill is about righting wrongs. If you recall, the purpose of the Maryland Police Accountability Act was to ensure that discipline and misconduct was handled in a transparent, effective, and fair way. We were assured that the Maryland Police Accountability Act was about taking care of issues associated with bad officers and had nothing to do with the good officers. The show cause order bill legislation before you is specifically to protect the good officers and the due process of all officers. If you think that there are provisions of law that are not being violated and have not been violated under the Maryland Police Accountability Act since its implementation, you would be flat out wrong. It has happened, as Mr. Davies said. This provides a mechanism to address situations where an officer is illegally suspended outside of the provisions of the Maryland Police Accountability Act, where an officer is demoted without a trial board, where an officer is denied an ability to work secondary employment, where an officer is transferred or suspended for whistleblowing. If you support the good officers, you must provide protection for them. I myself have been subject to a transfer prior to the Maryland Police Accountability Act because I blew a whistle, because my agency was not informing me in my position. I was in charge of revoking people's ability to access state and federal criminal justice databases. They were not informing me when employees were terminated. Therefore, I couldn't terminate their access. People maintained access to those databases after termination. And when I raised the issue, I was transferred. This is a previous administration. I want to be clear. This does not happen under my current chief. But these things happen. And it is important for officers who are subject to these actions that should be protected to be able to make a timely petition to the court and not have this take years and months for them to get a remedy for their rights, the specific rights that you enshrined in the Maryland Police Accountability Act. And therefore, we urge your support for this measure. Thank you.
I love the term judicial economy. It was amazing.
Chairman. Thank you, colleague, for bringing the bill. How, and forgive me, it's not my area of expertise. How is this different than an appeal? Like if you get an unfavorable decision and you don't like the decision, typically you appeal. How's this different?
Right. In a general, normal disciplinary case, if you get a decision you don't agree with, you have the right to appeal to the circuit court. This gets into the court on not only disciplinary issues that will come up in the trial or issues that will come in the trial that we can get out in front of it, or there are a lot of aspects of the Maryland Police Accountability Act that don't even involve discipline. There are other issues involving secondary employment, whistleblowing, due process issues, discipline prior to the trial board even occurring, that the administrative law judge and the one retired district court judge who hears these cases just don't have the authority to even intervene in. So this allows us to get into the court prior to any hearing or to resolve issues that don't even go to a trial board. There's just no mechanism for doing it at this point.
Does it shift the burden when the mechanism is show cause?
If it's a show cause, the officer would file a petition. It would go to the court. The judge would look at it and say, yes, I think there might be an issue here, and then give an order to the department to show cause why they did what they did and why it doesn't violate the law.
So it does
It does,
shift
yes.
the burden?
Yes,
Okay.
it does.
I think we had a bill last year. It was dealing with something about the timing, and these things have to be investigated and adjudicated within a certain amount of time.
Yes.
If you have the ability to kind of in limine, have a show cause that you can petition to the court for, does the bill say that it would toll that time that you have to complete the investigation and adjudication in?
It's apples and oranges. By the time you would file that show cause, if it was disciplinary related, you had already been charged and the statute of limitations would have already been met. It would there only is a statute of limitations for when the officer gets charged. There is no statute of limitations as it pertains to when his trial board or hearing will take place.
So typically, there's just a bedrock of the Constitution is you want a fair, you want a speedy trial, whether you're a criminal defendant or whether you're in a administrative disciplinary process.
Yes.
The reasons you want that, because the evidence is the freshest in people's mind. You want to make sure you can have things done as close to the time frame as possible.
Absolutely.
With the ability to petition show cause per each individual decision that you find unfavorable, does it have the ability to protract the process in such a way that we could take something that, let's say we waited until a final judgment and then you appealed your final judgment, you have the process proceed in a linear way. Mm-hmm. But if you can petition each individual decision that you don't like for a show cause, where you shift the burden back on the department and then you have to litigate each one in an a la carte fashion, are we at risk of protracting and bloating that process in a way where we slow down kind of the wheels of the mechanism to make it a longer, more protracted process?
I don't think that would be the case. Generally, if you're going to file a show cause, you're going to file it on whether it's 1, 2, 3, or 4 issues that have already been identified, and it'll all go at one time. The problem we have, and under the Law Enforcement Officers Bill of Rights, we had the ability to file a show cause. The departments did not have to stay the trial board. They could if they wanted to, but they didn't have to. There's case law on that, which generally, depending on the jurisdiction, you could get into court in a month a week, 2 weeks. It really depends. Some might be a little bit longer. The way we have it now under the current law, I would have to file, if it's disciplinary related, a motion to stay and a writ of mandamus. The courts have pretty much taken the writ of mandamus no different than any other lawsuit, which means it just goes into the stack, and that in itself can take months and months before it would be heard. We believe that pushing the show cause would actually speed up that process if it were needed.
Does the writ have a similar burden shifting aspect to it?
It does.
Thank you. Thank you. Thank you, Mr. Chair.
Would you mind if I add something? Sorry.
I liked your analogy where you're talking about linear versus going through this. What the show cause does is it prevents a circular motion, because what you're going to end up happening is you're going to go through the trial. That's when the appeal rights kick in. That's when the attorneys and the officer go to court. And if the court says, yep, you messed up, now you've got to go all the way back around to the beginning and start over. Whereas the show cause allows the issues to be handled linearly. You can address the issue, make any corrections you need, and move forward so that you don't have to go through an entire process and then loop all the way back and do it all over again. So that's why Mr. Davey was saying that it probably in a lot of cases would speed things along based on how the process currently sits.
Thank you for the question.
Thank you. And I have a feeling that my question should be asked later. So, because I think I have such a fundamental lack of information about this whole process. I was not in the General Assembly for this period of time. And you know, you don't come back here and read every law you missed, right? And all the reports. So I'm probably lost in this whole police accountability board and discipline. So briefly, and if this really gets protracted, we'll talk later, Senator. But it seems to me, initially you're asking for a police officer to be able to sort of get around the normal channels that are kind of administrative, right? I'm understanding this board is administrative, and if you have an administrative decision and there's a complaint about it, there are ways to go through this, and you want to sort of circumvent that and get to the circuit court. So I'm fundamentally wrong about all that.
Yeah, we're not trying to get around anything.
Okay. Well, I didn't mean to use that.
That's okay.
Maybe I'm speeding up a lot and take a shortcut.
There are two aspects of the Police Accountability Act. Okay. One is discipline, and the other one has to do with the other issues that we talked about as far as violations of secondary employment, whistleblowing, things of that nature. As it pertains to the discipline aspect, generally what we found over the last 4 years of doing these cases with administrative law judges, generally, you bring certain issues that they have jurisdiction of and can explain and rule on. Then if we're not satisfied with that decision, then we go to the circuit court on an appeal issue.
Okay.
The ones that we're concerned about are certain issues that they simply don't have jurisdiction of, and I mean the ALJs. I can give you the best example I can give you is the case I handled in Cecil County involving a police department where an officer was charged. He hadn't had his trial board yet, but the department demoted him anyway as a result of that disciplinary case. I went to the prosecutor. I said, you can't do that. You can't discipline him until he has the right to a trial board. Right. He said, well, we're doing it anyway. That is something an administrative law judge during that hearing would not have the authority to hear. How they handled it.
I'm sorry, you say is that clear? No, this is no disagreement. The ALJ would just say, this is not for me. So if they don't have the jurisdiction, who does have the jurisdiction?
That's the problem. Today, we now have to file we have to file a motion to stay the discipline, and then we have to file a writ of mandamus to get it into the circuit court to say the jurisdiction is not following the law.
Okay, and have you done that in any case in which the circuit court has said, yes, you're right, that's the right route to go because,
the case that I just described, finally the attorney convinced the police department they were wrong and they reversed their decision and gave him back.
But that doesn't help my question.
No, it doesn't. We have a couple cases pending right now in the circuit court on writ of mandamus. Both of those currently have to do with the Maryland Public Safety, the Police Training Commission. In cases, what we're having now, unfortunately, is a problem is we're going to trial boards. The cases have been dismissed on a motion or something of that nature. The officer should then be resolved, But now these agencies are going to the Police Training Commission and having their certifications revoked, completely bypassing the law.
Is it possible to just augment the Administrative Procedures Act or ALJs and give them specific enunciated authority here as opposed to your remedy? I mean,
I wouldn't know how you would go about doing that.
Okay, all right, I have to cogitate on that and find out why they don't have jurisdiction and a little more, because I feel like this is obviously an inadvertent mistake, if you will, when the bill was drafted. I don't think anybody decided to put law enforcement in a place where nobody knows where they're supposed to go, or it becomes very elaborate and was not intended. Just trying to figure out the best way to resolve.
The biggest problem is the two-prong aspect, honestly.
Right.
Part of it is discipline, and the other part are the other provisions of the law that simply don't involve discipline.
Right, but since we've bifurcated it, we can come up with a remedy. I think we just didn't see this when it was drafted. All right,
We actually have a meeting with the Maryland Chiefs of Police next week to see if there's a way we can work this through.
All right, thank you, Mr. Chairman.
Further questions from the committee? All right, thank you all very much. Thanks.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 202. We'll now move on to Senator Folden and McKay with Senate Bill 27.
Thank you, Mr. Chair, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings. For the record, William Folden, State Senator for District 4. Before you today is Senate Bill 27. In short, this bill deals with the regulated firearms and a 7-day waiting period exceptions. So currently, we have laws on the book where subjects that are current firearms owners, and concealed carry permit holders and/or current law enforcement or retired law enforcement who are all legally allowed to carry a firearm throughout the state are prohibited from going and purchasing a handgun. I want to make sure I make that stipulation, not a handgun. They're legally permitted and trained to carry a handgun, to own one, to possess one, to carry it throughout the state. And what this bill would do is enact a provision where those concealed carry holders, permit holders, law enforcement officers, and retired law enforcement officers would have an exception to the 7-day wait period. Currently, law enforcement, or currently any citizen within our state can go into a sporting goods store or a handgun, a firearms store, and they can go in and they can buy high-powered rifles. They can buy rifles with ammunition, and they can walk out that same day with that firearm in possession. What they can't do, even though some people may own many that are current permit holders, they're not allowed to walk in and buy a handgun without waiting an additional 7 days and coming back 7 days later after, according to current policy. This bill in no way strikes any provision of doing an NCIC background check, checking for any, protective orders, anything of that nature. What this bill does is simply facilitates the opportunity for those that are currently lawfully in possession of a firearm, of a handgun, to be able to buy one, and who are trained to be able to buy one and walk out with it the same day. It would still, again, all the same background checks with the federal NCIC system would still be in place. With that, Mr. Chair, to give me one moment. One of the reasons behind this is obviously with the Bruin decision that came out of New York, they made it clear that the regulation to right to bear arms must be justified by the government, which must demonstrate that it is consistent with the historical tradition of firearm regulation. The importance of that is when we go to an additional case, and I'm sure probably Mr. Pennick or someone might actually testify to this in greater detail than I, when we look at the 10th Court of Appeals, Circuit Court of Appeals, in, I guess, last year, they found it to be unconstitutional for the 7-day waiting period to be imposed in New Mexico for firearms purchases. That common sense dictates that the right to bear arms requires a right to acquire arms, just as the right to free press necessarily includes the right to acquire a printing press, and or the right to freely practice religion necessarily rests on a right to acquire a sacred text. So because of those reasons, I would ask for your favorable report on SB 27, and I'm happy to take any questions from the committee.
All right, we'll hear from your two panelists, and then we'll open it up.
Thank you.
All right, Mr. Jocelyn, you're up first. Welcome.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland. I'd like to compliment Senator Folden on stealing most of my thunder. One of the advantages I have as a gray hair is that I remember the old days when the 7-day waiting period was first initiated. The reason for the 7 days was because all of the paperwork, and it was literally paperwork, was submitted to the state police by U.S. mail and returned to the dealer by U.S. mail. Hence the need for 7-day turnaround time. In today's electronic world, that need is no longer in existence, and this particular bill has the advantage of not holding up a transfer simply because the law once said 50 years ago, 7 days. We strongly support it, and we ask for a favorable report.
Excellent. Thank you very much. All right, Mr. Pennick, welcome.
Thank you, Mr. Chairman. Mark Pennick, President of Maryland Show Issue. You have my written testimony on this bill in support of it. I would like to particularly draw your attention to a case that Senator Folden mentioned, which was the 10th Circuit's decision in Ortega versus Grisham, which struck down a virtually identical 7-day waiting period imposed by New Mexico law and held that was unconstitutional, and it was a Second Amendment. So what this bill does is eliminate the necessity for an arbitrary waiting period even after a background check has been completed. So the NICS background check is typically completed in 10 to 30 minutes. The state police do their investigation and background check, and typically the same day. So the need for a 7-day waiting period simply disappears. So it's right on my list of things to do is the challenge to this arbitrary 7-day period after a background check has already been completed. The state police would still get the application forms under Section 5-117 and 5-118. That's often called the 77R application. State police can use that same information to register the firearm to the purchasers, just as they do now. So there's really no reason to wait. All that application is now online. The purchaser must fill it out online. So the state police has that information immediately. The registration process will take place immediately, and there's simply no reason to wait an arbitrary 7 days beyond that period. So I would welcome any questions the committee may have. Thank you.
Excellent. Thank you very much. Questions from the committee? All right. Seeing none. Thank you both very much.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 27. We'll now move on to Senate Bill 81. Senator Folden.
Thank you, Mr. Chair. If I could call up my panel, Mr. Chair. Okay, Mr. Chair, Mr. Vice Chair, esteemed colleagues, Judicial Proceedings. For the record, William Folden, State Senator, District 4. Before you today, Senate Bill 81. This is really just a cleanup bill to some of the similar laws, I guess, that we've experienced and that we've dealt with in the past regarding someone that's in the care and custody provision, like in teachers or the like. The purpose of this is to prohibit those that are school resource officers who are entrusted with the care and custody of our children and protection of our children within the schools, that even though one may be an age beyond that, or beyond the legal number of 18, if they're still in the care and custody of that law enforcement professional, that there can be no inappropriate relationship. And I'll let my panel discuss further into that. This is something that's important because we want to make sure that we're doing our part to ensure that our law enforcement professionals, that, you know, we want them held to this standard. And you'll hear about a specific incident where something like this unfortunately happened and is the justification and reasoning behind this case or this piece of legislation. But again, very important on the idea of care and custody, that the same standard that they entrust someone with caring for a student who's enrolled in a school where the law enforcement officer is assigned to that school, that regardless of their age, even if they're 18, if they're still enrolled in that school as a student, that same protections would apply to them until they graduate. So with that, I'm happy to answer any questions, but I would ask for your favorable report on SB 81, and I'll turn it over to my panel.
Good afternoon, Mr. Chair, committee members. My name is Joyce King. I'm Deputy State's Attorney in Frederick County. I'm here on behalf of the Maryland State's Attorneys Association asking for a favorable report. I did take note that there was no opposition to this bill, so hopefully it's very straightforward. This is to ensure that there is no loophole within the existing statute of person in position of authority, and we codified this, or the bill language under 3314. The legislature already took the position that law enforcement officers that are responding in their official capacity and their duties should not have sexual contact with witnesses, civilians, of which they're enshrined to protect. In this case, school resource officers, that fell through the gap. We had a case in Frederick County where a senior at a high school came forward, got a rape exam, and stated that she was raped by a school resource officer. Upon review of the facts of the case, because he had waited and groomed her until she turned 18, we could not prosecute it. We conferred with the Office of State Prosecutor. They also did submit written testimony as to why they could not prosecute that as officer misconduct as well. We believe that this bill fills the gap, so if, and God willing, this does not happen again, but if it does, we will be able to prosecute it. This has tremendous support from MLaw as well as the Commission for Women. We believe it's a straightforward bill, and I'm ready to answer any legal questions if there are any. With that, I ask for a favorable report.
Mr. Chair, members of the committee, good afternoon. My name is Lieutenant Colonel Jeff Eiler, and I'm the Law Enforcement Bureau Chief at the Frederick County Sheriff's Office. Thank you for the opportunity to testify in support of Senate Bill 81. This legislation addresses a critical issue, protecting students from sexual exploitation and abuse by individuals who are placed in positions of authority and trust within our schools. School resource officers serve as an important role in maintaining safety, building positive relationships with students, and supporting local communities. With that responsibility comes a clear expectation of professional boundaries. SB 81 strengthens Maryland law by explicitly prohibiting a law enforcement officer assigned as a school resource officer from engaging in sexual conduct or sexual acts with a student enrolled in that school. While such conduct is unethical and may, keyword may, violate departmental policy, this bill ensures that law clearly reflects the seriousness of this abuse of power. Students are uniquely vulnerable. The presence of a law enforcement officer in a school carries inherent authority, influence, and control. Any sexual relationship between school resource officer and a student, regardless of perceived consent, represents an imbalance of power that undermines student safety and erodes trust in both law enforcement and educational institutions. This bill is not about questioning the professionalism of the vast majority of SROs who serve honorably and with integrity every day. Rather, it's about accountability, clarity, and prevention. Clear statutory language helps protect students, support ethical officers, and reinforces public confidence by making it unmistakable that such conduct will not be tolerated. By closing gaps in existing law, SB 81 sends a strong message to Maryland that Maryland is committed to safeguarding students and holding those in position of authority to the highest standards of conduct. For these reasons, I respectfully urge a favorable report on Senate Bill 81. Thank you.
All right, now we'll switch to our panelists joining us virtually. We'll start off with Ms. Jordan.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 81. Senator Folden, thank you for your leadership on this issue. You know, my role here is often to bring you the perspective of survivors. And from the perspective of kids at schools, whether they are 16, 17, 18, or younger, resource officers, they are law enforcement. And if you look at your fiscal note, it says a school resource officer is a law enforcement officer. They should be treated as law enforcement officers under our statutes. It's a little puzzling to me that we weren't able to to stop this predator. In this case, it's a terrible thing, but it's exposed a gap in our law. Senate Bill 81 will close the gap and protect students from exploitation. So for those reasons, we ask for a favorable report.
Excellent. Thank you very much. All right, now switch on to Ms. Garth.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Jessica Garth. I am the chief of the Special Victims Unit at the State's Attorney's Office for Prince George's County, and I am in strong support on behalf of my State's Attorney Tara Jackson as well as the MSAA. There currently is a loophole, as you're well aware, that allows the exploitation of relationships and inherent power imbalances between school resource officers and students, even students that are over the age of 18. In my position as the chief of the Special Victims Unit, we see many, many cases where these sorts of power imbalances and relationships are exploited to the detriment of children and students. One example that occurred in Prince George's County involved a 16-year-old girl who formed a relationship with a school resource officer. She was involved in a fashion club, and she was also having some trouble at home that made her the perfect victim for the school resource officer to prey upon. He started coming in and out of the fashion show rehearsals. He built a relationship with her, and eventually it escalated to an inappropriate sexual relationship. Now, since she was 16, none of the age-based laws were applied in this case, and because the relationship was quote-unquote consensual, we could not proceed on any criminal charges under the current statutory scheme that we have in place. Senate Bill 81 would serve to close that loophole. It would prevent further victims like this girl from existing in Maryland and in our communities, and as such, I do urge a favorable report. Thank you.
And Mr. Chair, if I may, I do want to add one closing part to this. So this officer is no longer employed. He's no longer employed by Frederick County. But I want to make it very clear also that it made it very challenging not having this law in the books, because through the MPAA, the most that he could have been charged with was a Class A violation, conduct unbecoming. So this is not okay. We want to make sure we're keeping our, putting safeguards in place to keep our students, our children safe from those that otherwise have, ulterior motives and unscrupulous motives.
Well, you got two bills on this list that I like, so this is one of them. Let's get,
really?
Yeah,
this one and the last one?
Oh, there you go.
That's
not
awesome.
The last one, not the last.
Are we on the record? Is that?
Not the last one. All right. All right. No questions? All right. Thank you very much for bringing the bill.
Thanks.
All right, with that, that'll conclude the hearing for Senate Bill 81. We'll now move on to Senate Bill 105.
Okay, so Mr. Chair, Mr. Vice Chair, esteemed colleagues of Senate Judicial Proceedings Committee, for the record, William Folden, State Senator representing District 4. Before you today is Senate Bill 105, and this is Real Time for a Violent Offenders Act. We've heard this bill repeatedly called Jerry's Law, and unfortunately, we're unable to keep moving with good traction. And this is, I think this is a very reasonable request. We moved a piece of legislation last year, as I recall, relative to those that were charged and convicted of rape. Because what we didn't want to do is we put a limitation on the diminution credits, because we didn't want to have victims re-victimized repeatedly as they would come eligible for parole way too soon in a matter of legal perspective. Oh, there she is. Glad you were able to make it. It's good to see you. Sorry you couldn't get out here. So I'll let my good witness, my good friend here, Ms. Duncan, talk about her mother. But I want to make sure that we're looking at, sentencing should have meaning, and sentencing should be relative and commensurate with the crime, and it should have real time associated with it. We shouldn't have those that are convicted, that are arrested, charged, and convicted for first and second degree murder, depriving loved ones of a relationship for years beyond that, and still allowing those that took them from us the opportunity to accrue diminution credits at an unbelievable rate that cuts their sentence in some situations by half or more. This bill would just say that not that they're not eligible for diminution credits, but that the maximum amount of accrual of diminution credits would be no more than 10% of the total sentence, the total of 10% of the overall sentence. Apologize. And I think this is a reasonable request because those that are the most egregious acts and depriving us of our loved ones stand to come back and re-victimize our communities, and we don't want to have that, especially with people that our guidelines need to have teeth and they need to have meaning, and people need to understand when they're sentenced to that it's not just a number that gets cut in half because of diminution credits, but because of these violent offenders, we don't want to re-victimize those families that have lost their loved ones all that much earlier by having these unnecessarily early paroles and release hearing dates. So with that, I'm going to turn it over to my panel, but I would ask for your favorable report on SB 105. Thank you. Doing my best, buddy. Come on up.
Good afternoon, Mr. Chairman, Vice Chair, and members of this committee. My name is Carrie Borzilleri, and I'm an Assistant State's Attorney in the City State's Attorney's Office. I've been a prosecutor for approximately 12 years over the course of my career. I appreciate the opportunity to testify before you. I'm here today to provide testimony on behalf of the Maryland State's Attorneys Association, as we did last year. We support Senate Bill 105, Real Time for Violent Crime, Jerry's Law. It is important that the amount of time violent offenders serve resembles the actual sentences imposed by the judges. By prohibiting diminution credits for individuals convicted of first and second degree murder and limiting the amount of credit violent offenders can receive, the Maryland Parole Commission is given the opportunity to make more early release decisions. It is imperative that the parole process be utilized as intended in order to ensure public safety. In allowing the Maryland Parole Commission to make the early release decisions, the individuals are subject to risk assessments and evaluations regarding their rehabilitative progress, as well as their likelihood of recidivism, rather than being automatically released based on diminution credits. Too often, violent offenders are released after serving only a small portion of their sentence, resulting in more violent crime, as seen as in the Pava-Lapierre case. The sentences served by violent offenders should mirror the actual sentences imposed by the judges, and any early release decisions should be made by the Maryland Parole Commission. We would like to thank Senators Folden and McCabe for sponsoring this bill. We urge a favorable report on Senate Bill 105. Thank you.
We'll now switch to the virtual panelists. So, Ms. Duncan, welcome.
Thank you. Hi, my name is Linda Duncan. Can you hear me?
Yes, we can. Yes, welcome.
Oh, okay. Hi, I'm Linda Duncan. As many of you know, I've gone down this journey with quite a few of you. But I would like to tell you a story relating to the crime of first-degree rape and our governor. But first, I want to thank the various members of this committee who have sponsored and co-sponsored Jerry's Law throughout the past 10 years that I've been coming through. I really appreciate your support. We need to equalize the distribution of what governing officials call justice for all. I am here to request the elimination of diminution credits used to reduce the time served in convictions of felony first-degree murder. Equal justice shouldn't be a contingent on a certain race and the population of the incarcerated as far as how long they would have to spend, the age of a victim, or even protecting the workers, or because you are a personal friend of a highly ranking government official like Wes Moore. In January of last year, the Lapierre family, whose daughter Pava was raped and murdered, testified before the committees for the bill to eliminate diminution credits of the term of confinement on first-degree rape and first-degree sexual assault. Within 6 months from the time it was presented, the Pava Act was passed by the committees and signed into law publicly by Wes Moore. As he stated, She was my friend. Yes, her family and Paula were close friends of the governor. Yes?
So I'll give you your time back. I want to make sure we're not impugning the motives of our chief executive for signing a piece of legislation that was passed through both chambers of this body. I just want to make sure that we just remain on the level and not impugn the motives of our governor in signing a piece of legislation that was duly passed. And by the way, I was the sponsor of that bill. I just want to make sure that we just stick on the substance of the bill, if we could.
Right,
please.
this is on the substance of the bill. However, I started my battle in 2015 after hearing of my mother's killer's early parole due to dim credits. And for 10 years, I've testified before this committee and other committee to pass Jerry's law that would eliminate dim credits, not to be used during the time of a confinement. I mean, not to be used to reduce the time of confinement. The only difference in the Parva law and the Jerry's law is the act of crime. You have first-degree rape versus first-degree murder. Why? What's the problem with Jerry's law? The Senate, for this state, we have a very lenient laws for murder. Our rape crimes are a lot stronger than our crimes of murder. I would like to ask favorable this year to pass Jerry's law to eliminate diminution credits, not to be given towards the reduction of time, but to be used within the confinement during the incarceration, but not to take time off of the sentence. Thank you.
Excellent. Thank you very much, Ms. Duncan. We're now going to turn it over to the committee for questions for the proponents of the bill. I think Senator James has a question.
Yes. Thank you, Senator. This is Senator Folden Day in Annapolis, which is nice. And but once that happens, this is it, right?
That's it. That's it. Everything's downhill.
It's your day. The couple of questions I had is this bill, given that we were talking about the other bill regarding the young woman's brutal murder and rape, is this similarly drafted so that what we're doing here is similar to what we did in that terrible case of the young brilliant young woman that was brutally murdered and raped? Are they similar? Maybe I should ask the state's attorney. As drafted, is similar in some ways to what we did in the other case, or did we do more in that case? I thought we may have denied some ability to bring down your sentence for good behavior. I forgot.
For the first and second degree rape, there's zero opportunity. It's my understanding. Yes, and for this it would be.
Okay, go ahead.
Yeah, it would be the same for first and second degree
So
murder.
they're similarly postured. That's all.
Yes.
Sorry, just because for me, I just wanted to know that. And I do share your concern, Senator Folden, that the public does not understand when they're in court, that they hear a sentence, and they don't understand that sentence is perhaps not the true sentence. Of course, many ways to bring down the amount, which I almost wish courts would just tell the public each time, because then at least people wouldn't feel so violated by all the notices they're going to get when people start asking for their early releases and all that. So that's shocking. So I'm not sure this is exactly how to address that issue, but truth in sentencing so the public understands what this means.
As well as those convicted. Meaningful,
That's true.
right? Yeah.
Right. Now, the only thing I want to ask about is in terms of, being supportive because these crimes are so bad, particularly because out of anything else in the world, you're never getting your loved one back, okay? Never.
Right.
Okay, that's it.
Yes.
But I don't know if anybody would say limiting, what other tools can we use to get better behavior or good behavior, even by these individuals who we do not want to escalate risk of violence uncooperativeness or whatever else. So yeah, I know this is a carrot and stick thing. So
Yeah.
how would you address that we're taking away a carrot just for the good behavior in the.
Right. So thank you for that question. That's a great question. And obviously we've thought about that. We've had those discussions. There's still ways to incentivize good behavior. You know, there's the opportunities to go in and have additional training or opportunities for trades or you know, to work in the shop or commissary privileges. There's obviously different manners to encourage that behavior. Okay. It's just a matter of right now, there's a lot of opportunity. You know, there's very little deterrent that should something, you know, flare up as far as that would affect their diminution credits. It's a lot more difficult seemingly to take away the diminution credits than it almost seems to be like an absolute right that they're going to get them, contrary, short of something pretty egregious.
And then just so I understand clearly, this nonetheless does not deny someone in jail for these terrible crimes from requesting, you know, an early release or parole through the parole commission. So this is just taking away that automatic dim credit.
Correct.
Then you kind of walk out and asking for the government.
Correct.
And the parole people who we can hold accountable to take a look on an individual basis in these particularly heinous and irreversible crimes.
Yeah, I mean, and this body did a really great job in examining last year's law when we passed it relative to rape and how it impacts the survivors. And this is another opportunity to take a look at the impact on those survivors, on their family, because the impact is severe. And the manner of death is, you know, a lot of times unexplainable on how someone could be turned so violent and take away the precious gift that is life. So we're just trying to really give parity in with those that are with the really meaningful legislation that we passed last year, as well as having a standard of expectation that those surviving family members won't be re-victimized early on following a sentencing that they think should be meaningful and substantial, only to find out that it can be cut pretty significantly.
All right, thank you, Mr. Chairman.
Thank you for your question.
Thank you, Mr. Chair.
Can I say something?
I want to make sure Senator Love just gets your question in. I want to, unless it's directly responsive to Senator James' line of questioning. All right. Go ahead, Senator.
Thank you, Mr. Chair. Good afternoon, Senator Folden.
Good afternoon.
So most of the discussion has centered on the diminution credit piece of this bill, but there's a second piece of this bill that talks about a judge's ability to authorize pretrial release of a defendant who's been charged with a violent crime. And I'm looking at the Maryland Judiciary's testimony, which focuses on that second piece. Mm-hmm. Have you had a chance to look at their testimony?
No, actually, I have not. I'm sorry.
Okay. We can talk about this offline, sure. But just top of mind response. Their concern is twofold. One, that it takes away a judge's discretion to mandate what they can and cannot do pretrial. And two, it conflicts with Maryland rules that require decisions whether to grant pretrial release be based on, quote, consideration of specific facts and circumstances applicable to the particular defendant, including the ability of the defendant to meet a special condition of release with financial terms or comply with a special condition and the facts and circumstances constituting probable cause for the charges. There's going to be a test on that, so I hope you can read
Actually,
it back
I did read that part now that you said that.
Great.
So I would say that the reason behind that is we don't want to have someone that has more financial means the opportunity to basically leverage their opportunity for bond or bail with the same crime, regardless of your economic status. We want them to stay incarcerated until this is played out through the courts.
Okay, thank you.
That's it. Thank you. Great question.
All right. Seeing no further.
I think Ms. Duncan wanted to add something, if we can, Mr. Chair.
Ms. Duncan, yes, if you have something responsive to Senator Love or Senator James' line of question, please. I think you're on mute, if we could unmute you.
You're muted, Ms. Duncan.
Or we can help. Can we help on this end?
Can you hear me?
Yes, ma'am.
Okay, I'm sorry. I just wanted to say that in my bills in the past and for this one, I'm not asking to get rid of diminution credits. I'm asking to redirect them. I even have a proposal that I'm ready to discuss with someone to amend the way we distribute the credits to the people. I mean, behavior is not rewarded and paid for, but it is acknowledged. And what we're doing with diminution credits is paying them. They don't do once they are back out, nobody's going to pay them to be good citizens.
Thank you for that, Ms. Duncan. You can go ahead and send that over to my office. I'm obviously happy to take a look at it. I appreciate that. Appreciate
Okay.
you taking the time to think outside the box to find a good solution. So thank you.
Thank you.
Excellent. Thank you very much, Ms. Duncan. Further questions from the committee? All right. Thank you. Thank you, Senator. And with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Ms. Tishwala and is Ms. Warkin here joining virtually, in person, both? Are they both here? All right, welcome. You're up. Mr. Tishwala, you're up. We can unmute you.
Can you hear me?
We can, yes. Welcome.
Thank you. Good afternoon.
Welcome. You're up.
Yes. Thank you and good afternoon, Mr. Chairman and members of this committee. My name is Benoit Shawala. I'm a paralegal. Can you hear me?
Oh, yeah, so yeah, we'll give you some more time. Don't worry. What you might want to do, you want to mute your browser if you're watching alongside. So mute your browser, and then we can commence with your testimony.
Good afternoon.
Or mute your feed. Yeah, mute the YouTube feed.
Yeah. Okay. Can you hear me now?
We can. Go ahead.
Okay.
We'll reset your clock though.
All right. Thank you. Thank you and good afternoon, Mr. Chairman and members of this committee. My name is Benoit Shawala. I'm currently employed with the Office of the Public Defender's Appellate Division as a paralegal. We urge an unfavorable report on Senate Bill 105. As a formerly incarcerated person myself who served 21 years and one of several who have benefited either directly or indirectly from diminution credits, I would like to address two specific policy interests from the vantage point of my experience, and those would be deterrence and also the safety of correctional staff. First, the bill greatly disincentivizes positive institutional behavior by incarcerated persons. At the beginning of my incarceration in 1998, I was quite disruptive and getting into fights and disrespecting officers. As a result, I was placed on segregation, transferred to a higher security prison in 2001. And although it was likely I would spend a significant part of my life in prison, my remorse, but along with the prospect of losing my good time, compelled me to refocus on certain things such as my reintegration, possibly, or education. In fact, I would be infraction-free for the next 18 years because of this. I earned a degree in sociology, paid for by myself and my family, and a paralegal certificate. These accomplishments opened up professional avenues that wouldn't have been available to me had I not changed my behavior due to the prospect of earning diminution credits. And I urge this committee not to deprive other deserving individuals of the same opportunity. Secondly, the prospect of losing diminution credits promotes safer interactions among incarcerated persons and with correctional staff, which I have seen firsthand. The passage of this bill will only exacerbate already violent.
You can go ahead and quickly conclude.
Okay. Finally, I would like to stress that my testimony is in no way meant to downplay the trauma of victims of crime and their families have experienced. However, I, along with many of my formerly incarcerated brothers and sisters, living proof that diminution credits have a substantial deterrent effect. In this regard, I'm not unique. We serve as the embodiment of what is possible with authentic remorse and behavioral change. Our success encourages those we have left behind. We urge an unfavorable ruling, unfavorable report for Senate Bill 105. Thank you.
All right, thank you very much. Is Ms. Warnken in the room? Okay. All right, with that, are there questions for this panel? Senator West, go ahead.
Witness, as I recall, we passed the first of these bills, was it last year or the year before, to eliminate diminution credits for people who are convicted of rape, and that resulted because someone who got out, having gotten the benefit of diminution credits for rape, then committed a heinous crime. And it was so awful that we reacted by saying no more diminution credits for rape. So I guess my question is, do we have any statistics about the recidivism of people who get out earlier as a result of diminution credits? Maybe you don't know the answer to that, but it'd be nice if it would be helpful to me anyway when considering this bill, if we had some idea of whether people who get out after receiving the benefit of diminution credits are less likely to commit more crimes or more likely to commit crimes. I don't know if you can answer the question. I think he's muted.
Okay, thank you for that question. Yes, obviously I won't be able to elaborate on any available empirics numbers on that at this point. I think that would definitely be helpful in trying to craft something that will be more in line with that, if that's the case.
Okay, thank you very much.
All right, further questions from the committee? All right, with that, that'll conclude the hearing for Senate Bill 105. We'll now move on to Senator Henson with Senate Bill 107.
Thank you. Good afternoon, colleagues. Thank you. This committee has engaged in a lot of really thoughtful discussion on the issue of doxing. So I don't think I have to give us a definition and tell us what doxing is, because I think we've engaged in a lot of thoughtful discussion on that from a lot of different perspectives and avenues in a lot of different contexts. But this bill is a reintroduction, so the testimony will be streamlined this year because we did have a broader panel last year. So we're going to streamline it to just a few virtual witnesses this year. I am Senator Shanika Henson, here to present Senate Bill 138. It is the criminal procedure sentencing. That's the wrong bill. I'm Senator Shanika Henson, here to present Senate Bill 107, criminal law distribution of students' personal identifying information. This is a bill that is an anti-doxing bill. The way that the bill works is it prohibits a person from distributing personal identifying information or images for students enrolled in secondary education or post-secondary education with the intent or knowledge that that information will be used to harm the student or with reckless disregard for the risk of the information being used to harm the student. It would make that activity a misdemeanor under Maryland's law. It's important for us to know that in the context of this, several other states have already taken action here, including the state of California, Colorado, Illinois, New York, Florida, Texas, and Washington. They've already beat us to the punch when it comes to protecting people from doxing, so we would be in good company here in the state of Maryland. Because of the very thoughtful discussions that we had on this last year, there are several changes to the bill from what we saw last year. One of them is a strong carve-out for First Amendment rights. So there is a carve-out for journalism, academics, and lawful disclosures. You'll notice that different from the bill as well. But we've tried to take a really thoughtful approach to address some specific activity that was harmful to students that we've seen in Maryland. And we're hoping that with the broad coalition that supports this bill and the work that we've done on the interim, that we'll be able to gain the support of this committee. So with that, Mr. Chairman, I would ask for a favorable report.
All right, we can hear from your panel, and then we'll go to questions. So, Ms. Chaudhry, and then O'Rear. Mr. O'Rear.
Here, thank you. Wonderful. Thank you.
Thank you.
And Ms. Sheik. And is Mr. Khan here? Is that you, Mr. Khan? Okay, come on up.
Good afternoon, Chair Smith, members of the committee, Zainab Chaudhry. I'm the director of the Maryland Office of CARE, the Council on American Islamic Relations. We are the nation's largest Muslim civil rights and advocacy organization. And I want to thank each and every one of you for considering this bill. I know last year we had several conversations with several of the offices in terms of how we can strengthen this bill to make it more impactful and really kind of address some of the underlying concerns that were raised by some of the committee members. We want to express our deep appreciation to Senator Henson for her leadership on this issue. This is an issue that doesn't just affect to one community. This is an issue that affects students from all walks of life, from all backgrounds, and my office has handled cases from Jewish, Muslim, Arab, African American, Indigenous peoples, Asian Americans, students who have been affected by the malicious online targeting of them, where their identifying information has been distributed without permission and consent, and that has led to malicious attacks against them. We are very pleased this year to have Attorney General Anthony Brown's support for this bill. You would have received a letter from his office in terms of their support for this legislation, and they are aligned with the National Association of Attorney Generals, who issued a report in August 2025 acknowledging the fact that doxing is becoming it's not a minor issue. This is affecting and impacting a growing segment of our population. Last year, in fact, according to studies, over 11 million Americans reported being doxxed. We have relatively strong anti-bullying laws, compared to other states. But the reality is that these laws do not match up to par with where, the issues that are affecting students in present-day society, in our communities and in our state across Maryland. And I really would just like to urge all of you to just recognize the fact that, we passed Grace's Law after a young child tragically died in circumstances that could have been avoided. And the reality is that many of the students, including a Jewish student whom my office advocated on behalf of 2 years ago, have reported to us that the harmful impact of doxing has led to suicidal ideation, and unfortunately the law does not protect students. So it's really up to each and every one of you to take action and not wait until, God forbid, there's another tragedy before we strengthen our state's laws to protect and provide common sense protections for students who are affected by this issue. Thank you very much.
My name is Grady O'Rear. I'm a Maryland resident, and I'm submitting testimony both orally today and in writing in support of the bill. This bill matters because it protects student safety without undermining free speech. Students should never have to choose between participating in civic life and fearing that their home address, phone number, or personal images will be weaponized against them. I speak from experience. Many years ago, as a student at the University of Maryland, I and many other students across the country protested the war in Vietnam and the bombing of Cambodia and Laos. Those protests were instrumental in helping to stop the carnage and to confront actions widely viewed as unlawful and immoral. History shows that organized, lawful public dissent is often essential to correcting government wrongdoing. That principle remains true today. When the federal government acts in ways that violate international or domestic law, it is especially important that residents, citizens, and local and state governments can stand in solidarity, openly and safely. Doxing is a form of intimidation designed to silence participation. This bill reduces that threat and helps preserve the conditions under which free speech is real, not merely theoretical. For these reasons, I strongly urge the committee to issue a favorable report on the bill. I also strongly urge you to use whatever powers you have, including those of you who, as attorneys or officers of the court, to stop the flagrant violation of domestic and international law that our federal government is regularly exhibiting. Thank you.
Thank you for the opportunity for me to testify today in strong support of Senate Bill 107. I'm speaking today from direct experience. Last semester, myself and other legislators at the University of Maryland College Park student government called upon our school to stop hosting war criminals from the Israeli occupation forces, a pattern that has repeated for decades on our campus. These speakers have no place on our campus, and we used our constitutionally protected rights to call to this change. As a result, we were doxxed by our own peers, including our school's Students Supporting Israel chapter, as well as numerous external organizations. Because of this, I was personally targeted at my workplace, which was flooded with hateful and racist messages about me calling for my dismissal. Comment sections online were flooded with racist and Islamophobic remarks. This was not simply an online attack, but rather a coordinated effort to punish me for speaking out as a Muslim. I am not alone, as 5 other student government representatives at UMD, all people of color, were also targeted. Some had no involvement in the resolution and weren't even voting members of this legislature. This was not an act of debate or free speech, but a coordinated intimidation of marginalized students in the SGA. Doxing is not merely an expression of disagreement. It is a weapon leveraged by racists and Zionists to silence people who dare to speak out against genocide. While Israel continues its assault on Gaza in violation of a supposed ceasefire, students who dare to criticize these atrocities are being silenced through fear, such as doxing. It has been 3 months since the ceasefire was signed, this same ceasefire that has allowed Israel and the IOF to kill over 470 Palestinians. The same ceasefire that allowed the destruction of over 2,500 buildings in Gaza. The same ceasefire that has allowed Israel from blocking humanitarian aid, such as food, bottles for baby formula, and syringes for vaccines. We are told that this is a democracy working for peace and an army that is the most moral in the entire world. The same moral occupation force has continued to bomb Lebanon and build illegal expansions into Syria. This issue affects countless students and people across this entire state of Maryland. It is a one-way street. Not once, at least on our campus, have Palestinian groups doxed white students, even those who harass, marginalize, and lie about us. For as long as you allow doxing to persist on college campuses, you uphold a system of oppression that intimidates students of color, particularly Palestinians and Muslims, from exercising their freedom of expression. We are entering college being...
Shaw, thank you very much. Your time's concluded.
Thank you.
Thank you very much. We're going to open it up for questions. Riona Sheik, you're up.
Good afternoon, everyone. My name is Riona Sheik, and I'm a student at the University of Maryland, College Park. I'm here to share my experience being doxxed as Vice President of UMD Student Government and why protections like Senate Bill 107 are urgently needed. On the evening of September 30th, 2025, I was in the middle of writing an essay. I decided to check my messages, and someone sent me a link to a Twitter post. It had thousands of likes and hundreds of comments. It was posted on an account with over 300,000 followers. And right there was a photo of my face with a few other students' photos on a black background with a caption that listed our job positions in the student government, our first and last names, and the caption saying, "Future employers take note." This account, Stop Antisemitism, sought to paint me and a couple other members of UMD's student government as anti-Semitic, but I didn't have time to be upset about the libel because the comments on the account were overwhelming enough. Hundreds of people were calling to deport us. Many comments said that we looked Muslim. They called us terrorists and terrorist sympathizers. I turned off my phone and somehow managed to finish my paper, but I felt really weird and I didn't know what to do. I hoped it would pass with time, but I was wrong because getting doxxed was very hard to get over. The next day, the post was circulated on many different accounts. I even saw it make the Atlanta Coalition of Israel. I felt horrible. I couldn't go to classes for a couple of days. I walked all the way to my class and stood outside the classroom door. I didn't know what to do with myself. And I started to realize that if my face and job position could be shared so easily, my address or my class schedule could be next. Because once something like this starts, how would anyone know where it ends? I felt exposed and vulnerable. I missed my student government meetings, and one of the worst things was telling my parents. I just felt so stressed and alone, and I couldn't do anything. If someone knows that they can do something this horrible with zero consequences, what is stopping them? If there's no barrier, someone who intends to bring harm will do it. I still don't know who did this to me, but I know they walk without consequences. Please, please vote in favor of this bill. I wish something like this existed before I got doxxed because maybe it would have prevented this from happening. I'm 19 and my focus should be on academics, not on whether I feel like I'm in danger. Thank you.
Thank you very much. All right, Senator Sidnor has a question.
Thank you very much. And first, I want to acknowledge the modifications that were made from last year, which are some of the concerns that I had mentioned regarding First Amendment. With that said, I was looking at the Office of Public Defender's testimony. Had you had an opportunity to look at that?
I have, thank you.
The scenario, two questions from that. The scenario that they mentioned on page 2, where they speak about this student running for the president of the student government. Do you have any concerns with that scenario playing out?
So,
and if I may, just because everybody doesn't have it in front of them, it says, imagine a scenario where a student is running for president of the student government. The candidate openly encourages the establishment of whites-only student group and argues that student associations based on national origins other than American should be prohibited. A fellow student posts a video on their personal social media page using the candidate's name and photo and comparing the student's candidate's positions to segregationists. This law would enable the student candidate to file criminal charges against the social media poster for intentionally or recklessly causing serious emotional distress. The use of the student government candidate's name or photo alone would bring the complained conduct under the ambit of this statute, even if the poster had a viable defense to raise at trial. And then they mentioned the ability for citizen complaint, which is another issue that we're going to be dealing with, or tried to deal with last year. Would you mind kind of speaking to this scenario?
sure. Two things about the public defender testimony. One, they are the public defender, so they certainly have a particular perspective. And the second, I don't know that that would meet the requirement for maliciousness. What they put there in that scenario is that the person, they identify the person who made the comment. They believe that the person is not in favor of their perspective. And so they say, hey, this person made a comment and I don't like it. And they post the person's name along with their perspective. I don't know that that rises to the level of malicious conduct under the law. So I think they might have trouble meeting that. And then you also raised what is an important analysis as well, is that it wouldn't by operation of law or automatically happen that you hit send on the phone or you hit post on the phone and then someone is charged with a crime. There's still a level of prosecutorial discretion where someone would still have to report an offense, a prosecutor would still have to charge someone with an offense, and then after that you still have all your due process rights where someone would have to go through a trial and then it would have to result in a conviction for the law to work in its full operation of the law. So I think under the scenario that's posed, it would meet a challenge, a struggle to even be charged as a crime. And then if it were, I think it would struggle even further to reach in a conviction based on the scenario they posed.
Thank you. And if, I believe Ms. Chaudhry, correct me, did you mention Grace's Law?
Yes, that's correct, I did.
Great. One of the other things that they mentioned in their legislation was, should the General Assembly wish to expand Grace's Law to protect secondary and post-secondary students, Grace's Law could be expanded to apply to secondary, post-secondary students and minors, where the statute currently reads minors. Is this suggestion, does this suggestion not get us where we're trying to go?
So what Senator Henson's bill does is essentially it builds on Grace's Law. It brings that statute up to par with what the current circumstances are for students in higher education, in post-secondary education. Currently, according to confirmation from University of Maryland Campus Police, Lieutenant Mabel, this is on record, who we spoke with. He confirmed that currently, as Maryland statute stands, Maryland police cannot do anything to protect students who are targeted in doxing because the laws are just simply not strong enough. We believe that there is an opportunity for the Maryland General Assembly to take Grace's law a step further, and as Senator Hinson has put together this legislation, really kind of make it more robust so that students have the same kind of First Amendment free speech rights. The reality is this bill actually strengthens First Amendment free speech rights because if students understand that they have those protections, they are much more likely to exercise those rights. Currently, there are so many students on college campuses who, for a wide range of reasons, are afraid to speak up on various causes and beliefs that they have just because they're worried about the repercussions of, how their views will be interpreted. And this is not just, again, Muslim or Arab students. These are students from all walks of life who are being affected.
Thank you.
Of course.
All right. Senator West is next.
Thank you, Mr. Chair. I'm looking at the bill on page 3. And the key language is a person who may not intentionally distribute the personal identifying information or image of a student, and then without the express permission of the student and with either the intent or knowledge that the personal identifying information or image will be used to harm the student or reckless disregard for the risk that the personal identifying information or image will be used to harm the student. So I don't spend much time on social media. My wife criticizes me for spending the little time I do. But social media is just full of photographs of people all over the place. And I guess my concern with the bill as written is that someone could take photographs with their cell phones of like a student demonstration, and the person taking the photograph is opposed to whatever the students are demonstrating in favor of, and then post the images online. And then someone does something that hurts one of the students whose image was posted online. And all of a sudden, the mere use of social media, because of this language about reckless disregard for the risk, you're gonna find the person who posted this image online, which people do all the time, is now arrested and charged with this crime. So how would you react to that?
I appreciate you asking the question so that the intent is fully clear. I think those two things are sequential because the intent of harm is the intent of the bill, and so the reckless disregard is linked to the intent of harm. So it is not a reckless disregard absent an intent of harm, but those two things are together and they are linked. So it is not that you take an image without a person's permission and you post it and you have a reckless disregard for anything, their discomfort, a reckless disregard for if they think that they don't look flattering in the photo, or a reckless disregard for whether or not they wanted it posted, but it is a reckless disregard for harm that would follow from that image being posted if we're isolating it to just the image and not the other PII. So those two things are linked together. So it is not that any sort of image that's shared without a person's permission, it is directly linked to the harm that would result and follow from the sharing of the image.
Well, let me just give you a hypothetical. So January 6th was an atrocious day in which our democracy was imperiled. And there were lots of people who took pictures on January 6th of the demonstrators attacking the Capitol. Those pictures later on were used by the authorities to arrest people, and my understanding is that some of the pictures resulted in the demonstrators losing their jobs and otherwise being vilified in their communities. So would it be possible for a prosecutor, sympathetic prosecutor to one of the protesters to say, wait a minute, under this bill, a person took a photograph of one of those January 6th protesters and put it online because the person putting it online was very much opposed to what the protesters were doing. As a result of it being put online, that protester lost his job and was vilified in his community. And would it be possible that under this bill that the person who posted that image online could find himself the subject of criminal prosecution?
I think two things there. One, it would harken back to the intent of the person that posted it. So if that person were simply having a picnic on January 6th and they posted a photo where you could see all the activity in the background and their intention was to simply show, look at me having a lovely time on January 6th, then we certainly would probe their intent. I think the second is your colleague from Baltimore County, some of what he helped us flesh out in the bill last year. If there is a required disclosure, let's say those photos were used by law enforcement, certainly those photos would have been subpoenaed and authenticated. And then at that point, we're not just talking about social media, we're talking about the subject of a law enforcement investigation. And so it takes the context of those photos in a very, very different direction. If those photos are the subject of journalism or if they have a First Amendment value, then we have made an exception and a carve out to what you would see able to be a misdemeanor here, where it would be in a different context and a different light. So in the scenario that you've shared, I could very well see someone being able to find one of those exceptions for those photos that you described.
Well, let me pursue this just with one more question. We all know that there's an extraordinary amount of hatred abroad in the land. People on the one side really hate the people on the other side, despise them, and vice versa. So let's assume the person that took those cell phone photos on January 6th really despised the people who were trying to support the president by attacking the Capitol and posted those pictures online hoping that those people would be vilified in their communities, maybe would lose their jobs. Would that make the posters of those images online subject to being prosecuted under this bill?
No, unless the United States Capitol is a college campus and those folks are college students. I think one of the other parts of our conversations is that what we sought to do was understand the unique nature of what happens on our college campuses, or specifically with our college students. We want those to be places where your free speech and where those opportunities to develop your voice, where you have those sort of important conversations, where you can have the protection of the safe spaces to do that. So that's why we limit it to persons who were students and who were in secondary and post-secondary education who were protected under this bill.
Great. I appreciate your answers. Thank you.
Thank you.
Thank you, Mr. Chair. So taking what you just said, Senator Henson, and applying it to what Senator West was saying, what if that somebody was a student and the photographer said, hey, this student is out there smashing our Capitol, attacking police officers. They're a student at UMD. UMD, what are you going to do about it? So is that person now going to be criminally prosecuted?
When you say a person took a photo and said that and identified them as a student, is this person that you're describing a journalist?
No.
Okay, so if they're not covered under any of the carve-outs for First Amendment or any of the carve-outs for required disclosure, if that person who posted is not subject to any of the specific carve-outs in this bill, then that's exactly what we're trying to protect. If a person is a student and a person is exercising a First Amendment right as a student, we want students to be protected while they're exercising their First Amendment rights. Now, there are certain things that if a student is committing criminal conduct, if they're in the Senator West scenario where they are trespassing, where they are assaulting a police officer, where they are maliciously destroying property, where they are, doing things that are criminal conduct, certainly those images would be subpoenaed and be a part of a court record, and they would fall within the sort of things that are not protected under this bill, where it would be subject to disclosure, and those images would be able to be captured.
So in my scenario, the photographer, not a journalist, captures a student smashing windows and assaulting a police officer. So I'm not quite sure, because I thought I heard two things in your answer. Is that person who posted that online, they're in public, they're doing this, says, hey, that person's a student at UMD. UMD, what are you going to do about this? Is that person in that scenario going to be criminally charged?
When you cross the line into an area where you're capturing someone committing criminal conduct, that's when you're going to lose the protection, because this says if it's a required disclosure, then you wouldn't be protected under the bill. The bill is designed to protect someone who's using their First Amendment right to free speech. Once you breach that barrier and you're doing the conduct that you described, the smashing windows and doing those other things, that's where we hope people wouldn't still, post people for those purposes. But once you're doing that, you would lose the protection of the bill.
Got it. Thank you.
Yeah.
Further, Senator McKay.
Thank you, Mr. Chair. Thank you, Senator, for bringing the bill. Why is the bill just narrowed to students' personal information, not the general public's?
We had those conversations, Senator, and in having those conversations, we looked at what some other states were doing too, and I'll tell you, some of those other states I referenced in my opening, they have broader protections for the public writ large, and we didn't find it appropriate with this bill. But I know that we have some other things we're working on as a committee to address doxing in various other ways in different contexts. So I certainly would be open to having those conversations and working at it from other areas and aspects. But for this particular bill, we were trying to solve a particular issue that was brought to our attention.
Yeah, I just don't understand if we're worried about the mental health of our youth because of doxing. I don't know why we have to tag it that they have to be a student. I think we do have other youths. And then I tend to believe as you extend that even larger, it's just the overall doxing is wrong.
There's someone else.
Isn't that so?
There's someone else on my panel that would like to address it. Would you permit, Senator?
Sure.
Okay.
Thank you.
Thank you.
Thank you for that question, Senator. That's a really important question. I would refer back to the August 2025 report by the National Association of Attorney Generals, in which they indicated that doxing is becoming a growing threat to Americans across the country. And according to that report, students are disproportionately impacted. Part of it, unfortunately, is because of the political climate that we're in. And unfortunately, students do tend to be more vulnerable and susceptible to these kind of attacks. CARE, as a civil rights organization, strongly protects free speech and First Amendment protections. So any bill that would extend those protections beyond students, we would want to look closely at what that language says and what kind of protections they afford. I think absolutely it's worth it to acknowledge the fact that our Constitution does protect First Amendment free speech rights, but it also has very clear positions on whether or not harassment is permitted, whether stalking is permitted, whether committing crimes against innocent people is permitted. And we shouldn't focus so much on hypotheticals in trying to protect students who are this is like actually their lived experience. And that report, I think, was very eye-opening. I would really encourage all of the committee members to read that report by the National Association of Attorney Generals. And again, we want to thank A.G. Brown for also supporting this bill as Senator Henson has drafted it, because I think it really illuminates the fact that Maryland has a lot of work to do to catch our laws up to speed, and you all have the power to really help make a difference in so many students' lives.
I look forward to reading that report, but I tend to believe that my responsibility on this committee is not to pick and choose individuals. If doxing is wrong, then it should be for everybody in the state of Maryland,
absolutely,
regardless of your age or if you're a student.
And we'd be more than happy to work on language around maybe future potential legislation that would extend those protections to all Marylanders. I absolutely agree with that. As long as it's constitutionally sound. Thank you.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you. And we'll now switch to the opposition panel. Is Lauren Dollar in the Zoom room? Is she in there? Hassan Islam and Diego Enriquez there first. Do we get their testimony? All right, we've got two more virtually, then we'll get to you, Ms. Dollar. Okay. Diego, you're up first.
Yes, hello. Okay, sorry about that. Okay, thank you so much for the opportunity. Yes, can you hear me?
We can, yes, go ahead.
Thank you so much for the opportunity to testify today in strong support of Senate Bill 107. My name is Diego Enriquez, and I'm a junior at the University of Maryland College. I'm also a member of the Student Government Association. Oh, sorry, my mic was feedback. But I am not here today on behalf of the organization. I am here as a student leader and frankly as someone who is scared for my friends. As a representative body, the SGA has taken principled stances on global human rights issues, including resolutions advocating for Palestinian rights, recognizing the genocide in Gaza, and calling for divestment from companies complicit in human rights violations. These positions are rooted in justice and solidarity, yet some of our members who spoke out have been subject to unprovoked and targeted harassment. In response to exercising their First Amendment rights, they became targets of malicious doxing by Stop Anti-Semitism, an Islamophobic anti-Palestinian social media account that purposely distributes students' personal identifying information with the intent to harm them emotionally, socially, and mentally. The posts doxing SGA members always ended with a call for future employers to beware. This was a blatant attempt to intimidate, silence, and punish students for advocating for human rights and standing in solidarity with Palestinians. Senate Bill 107 provides a clear, necessary protection. It does not restrict lawful speech or protest. Instead, it ensures that students can engage in meaningful debate, advocate for human rights, and participate in our democracy without being subjected to targeted, harmful, and intentional threats. Don't students deserve the same right to protected speech as anyone else? Why should they face real-world danger for simply standing up for justice? For these reasons, I urge a favorable report on Senate Bill 107. Thank you so much.
Excellent, thank you very much. All right, Mr. Islam, you're up.
Hello. Yes, thank you for the opportunity to testify today in strong support of Senate Bill 107, which would prohibit the unauthorized distribution of students' personal identifying information with the intent to harm. My name is Hassan, and I'm a senior at the University of Maryland. Last semester, 2 undergraduates and I at the Student Government Association were doxxed by Stop Anti-Semitism on Twitter and Instagram. They claimed we personally banned IDF members from speaking on campus, which, honestly, I wish was true. But at the end of their post, they called for us and our future employers to be aware of us, basically. So us not to get hired in the future. And one of the account's followers of this 300,000 followed account retweeted a hangman's noose. The same day, the local campus chapter, Students Supporting Israel, on their Instagram account posted our names and faces. For me, this type of intimidation isn't that big of an issue. However, I know some of my fellow students who this type of doxing caused immense mental stress and fear, where they ended up missing classes and other extracurricular clubs. If passed, this prohibition would work as a deterrent for people trying to intimidate students for their First Amendment right. In this era of the federal government being weaponized against its own citizenry, this state legislation would offer to be a stick to help protect our First Amendment rights that are being attacked daily. These are the reasons we want a favorable report. Thank you for your time.
Excellent, thank you very much. All right, questions from the committee? All right, seeing none, thank you very much. We'll now switch to the opposition panel. Ms. Dollar, you're up. Welcome.
Thank you.
Chairman and Vice Chairman and members of the committee. So my name is Lauren Dollar. I'm an attorney with the Office of the Public Defender, and I am testifying today to urge this committee to issue an unfavorable report on SB 107 as it is currently drafted. The goal of this bill is noble. Doxing hurts people, as we have heard about today, but pinning down how to draft an anti-doxing law is a challenge. So I'm an appellate attorney. And so when I look at a crime and whether the state has proven that someone has committed a crime, there are two pieces to every crime. There is the actus reus and the mens rea. And we also know that as an appellate attorney, the courts look to the plain reading of a statute. So an actus reus is what did you do, the conduct, and mens rea is why did you do it, which is the intent. And the problem with this bill is that the actus reus in this bill, what you have to do to break the law or be accused of breaking the law, is post a student's name online, or a fellow kid's photo without their parents' permission, or distribute a student club contact list with student names and numbers, or any number of very basic acts that people do all the time. And it applies to kids and to fellow students too. And so when the conduct, the thing that you have to do to break the law is very easy to do, the statute can be used to prosecute innocent and constitutionally protected actions, while the mens rea, the intent, and also whether the person being accused has a First Amendment defense, all gets teased out after charges are filed. As noted in my written testimony, this bill could be easily manipulated to target and prosecute people who talk about their personal experiences online with their own peers, or kids who post photos of their friends where their friends' parents don't like them or don't like their parents. Because this bill exposes innocent and protected conduct to prosecution, I urge an unfavorable report. Yeah, I'm just, yeah.
No, that's good. Good. All right. Questions from the committee? Senator Sidner.
Thank you very much. Your office posed on page 3 what seems to be a possible resolution to some of the issues you may have mentioned by essentially just expanding Grace's law to apply to secondary, post-secondary students and minors. It says where the statute currently reads minors. Is that a solution possibly to what it is that to the students that we're trying to protect from this doxing?
Yes, Senator, I think that if you read Grace's law, the actus reus, the things that someone has to actually do are more specific than just posting a name or image online. I think I personally read some of the parts of it a little broadly, even so, but it's already law. And I think that that would give the people who have expressed experiencing this horrible experience some avenues for relief without sort of passing a law where the plain reading of the statute. My primary concern is that the people that we think we're protecting are not going to be the people who are getting protected by this bill. It's actually the people we would like to protect are going to end up hurting because of this bill. That's my biggest concern.
Thank you.
Because of, yeah.
Additional questions from the committee? All right, seeing none. Thank you very much, Ms. Stoller.
Thank you, everyone.
And with that, that'll conclude the hearing for Senate Bill 107. We'll now move on to Senate Bill 138. Senator Henson.
Thank you, Mr. Chair. May I bring the panel?
Yes, please. Yes.
Good afternoon, colleagues. I'm Senator Shanika Henson, here to present Senate Bill 138, Criminal Procedure Sentencing Domestic Violence as a Mitigating Factor, otherwise known as the PATH Act, providing alternatives through healing for justice-involved individuals. The PATH Act is a piece of legislation that would be a sentencing modification bill. So we all know that there's kind of two phases in any criminal trial. You have your guilt or innocence phase, and then you have your sentencing phase. The PATH Act would kick in the sentencing phase after a person has already been found guilty or innocent. It would give them the opportunity to introduce domestic violence as a mitigating factor in the sentencing phase. This bill is supported by a broad coalition of folks who have come to this work by way of the work that they do every day. Supporters of this bill include the Women's Law Center, Helping Ourselves to Transform, the Roar Center, the Bowie State University Prison Education Program, the Maryland Catholic Conference, the National Center on Violence Against Women in the Black Community, the John R. Lewis Reentry Reform Services, the Ladies of Hope Ministry, Maryland Latinos Unidos, Montgomery County Democratic Women's Club. You have a letter of support from the Office of the Attorney General. You have a lot of support in the bill folder for this bill, and I believe it's because it's a really, really smart and thoughtful bill that I can't take credit for the thoughtfulness of it. It is the coalition that's behind it that really put the work in, that brought us a thoughtful solution to help survivors of domestic violence. We understand that far too many women in our criminal legal system are survivors of domestic violence. Research shows that up to 70 to 80% of incarcerated women have experienced intimate partner violence. Research shows that up to 60 to 70% of incarcerated women endure child sexual physical abuse. Research shows that 57% of domestic violence murders are not just, that there are racial disparities as well, and that 57% of domestic violence homicide victims are Black women. So we know that this data cuts across different lines in different ways, and we know that there are people who are acutely hurt by what we're seeing in the areas of domestic violence, and that this bill would bring some specific and timely relief to people who have suffered and then found themselves suffering under the criminal legal system as a result. We've tried to be really thoughtful about the crimes that we've included for relief under this bill, so not everything is included. Some of the most violent crimes, you will see that those were not included. And I think that it's the result probably of sitting in that chair there, here in JPR, and hearing from survivors' families, the reason that we didn't include some of the most violent crimes for relief under this bill. But we did include some things that you might not see included, things like crimes under the theft statute, because in speaking with survivors of domestic violence, we know that so many times that abuse turns financial, and people find themselves in those situations where the lever of control that's used is the power of the purse. And so sometimes the crimes that result or that are influenced or impacted by violence are things that are not always what you might presuppose would happen out of a domestically violent situation. So with that, colleagues, we have a panel of folks who have worked with people who are survivors. We have a panel of folks that include people who are survivors. And with that, Mr. Chairman, I would ask for a favorable report on this bill and for my colleagues to really absorb the testimony from the panelists that we have today. Thank you.
Good afternoon, Chairman Smith and other members of the committee. My name is Olinda Moyd, and I am here today testifying on behalf of the Maryland Alliance for Justice Reform. We urge a favorable report. I have volunteered for the last many years and represented individuals in our prisons throughout the state. When I interact with individuals in our prisons, they share their experiences of domestic violence and abuse, which in many cases led to their involvement in criminal activity. The bill is not about not holding defendants accountable. It is about, after a person has a conviction, whether or not the mitigation information regarding their circumstances, so that the judge has a look at the total circumstances and a full picture of their abuse and trauma, that is taken into consideration at the sentencing. Survivors of domestic violence often engage in criminal behavior as a direct result of abuse, coercion, and control by their abusers. Sentencing is just is a very critical phase in the criminal legal process. The judges must have before them all relevant information. This bill creates a framework for judges to consider domestic violence as a mitigating factor. One important piece of this bill is that it allows mitigation evidence to come in through reports and testimonies from family members, friends, counselors, medical professionals. And this is important because we know that survivors don't always report abuse to the authorities. We support this bill. We ask that you vote favorably and give voice to those survivors, especially women of color, who are often invisible in our criminal legal system. Thank you.
Senator Henson and all committee members, thank you for this opportunity to speak in support of SB 138. I submitted written testimony as a board member and the treasurer of the Women's Democratic Club of Montgomery County, and I'm also on the board of the Montgomery County Family Justice Center Foundation, and I'm a mother and a grandmother. I'm Deborah Williams, a lifelong Maryland resident with 46 years experience as a CPA, a certified money coach, a small business owner, and I speak here today as a financial and tax professional. In my business practice, I serve individuals, small businesses, nonprofits, and pro bono clients in accounting and taxation. During the 2008 recession, I lost most of my assets and had debts I couldn't pay that almost bankrupted me. I was clinically depressed. During my recovery, I needed a new way to practice accounting and tax so I could recover from the financial setback and understand why it happened to me. These stories begin in early childhood with parents, families, family dynamics, and other influences, and we evolve into adulthood. These are what I call money stories. Our self-worth is measured in financial success, and if we're struggling, we hide and avoid getting help. Most of my clients' conversations are about overwhelm, frustration, and mostly shame. We fear talking with our partners. We operate from our survival brain and not our mature brain. When addiction is involved, it's that much harder. I'm not a therapist, but I help clients identify root causes and connect to their money struggles. Clients can face things, see their strengths, and come up with a plan. Ultimately, the harms become redemptive and give us greater choice and contentment once we address the root causes. We explore our origin stories, work through shame and abandonment, and greater awareness grows. I am a survivor of domestic violence. My dad was verbally and financially abusive toward my mother during my entire life. I understand what women go through on a day-to-day basis to keep their families together and at great personal cost to their health. Domestic violence affects all parties and destroys the fabric of family life. I support Senate Bill 138, and I especially asked for it to be passed because of women of color and the good step that this would be for Maryland's women, families, and a stronger economy. I ask for a favorable committee report for a full vote on SB 138. Thank you.
My name is Reverend Melody Hession Sigmund, and I'm testifying in favor of this bill on behalf of the Delaware Maryland Synod of the Evangelical Lutheran Church of America. Last year, 3 Lutherans, members of our church body, and residents of Maryland Correctional Institute for Women submitted testimony in support of the Second Look Act, pouring out their hearts very eloquently into their letters. And sexual assault was part of all 3 of their stories in the context of the crimes. For none of them was their own trauma or victimization a meaningful part of the conversation during sentencing. Anyone in our denomination who's volunteered with our Lutheran congregation at MCIW learns from getting to know parishioners that in our justice system, each person is treated as either a criminal or a survivor. And unfortunately, there is very little room for anybody to be both, but many are. These 3 Lutherans I'm here for today are 2 women and 1 trans man. So we appreciate that this bill acknowledges that trauma-informed sentencing is needed for more than just women in this bill. Our church absolutely believes in more trauma-informed sentencing practices in our court system. We both urge a favorable report for this bill, and we hope that this committee pays attention to the lessons from this bill about who is already on the inside of our prison walls in Maryland. Thank you.
All right, seeing none, thank you all very much. Is Crystal Combs here? Missing anyone else? Is Juanita Scott? No, it's Juanita Scott. Is she in the room?
I'm good.
Okay. Dr. Johnson. What's that? All right, Dr. Johnson, you're up.
Good afternoon, President Smith, Vice President Waldstreicher, and members of the Judicial Committee. Before I begin, I humbly say I am under the care of my mental health doctor, and I appreciate your patience as I deliver my 2-minute testimony. My name is Dr. Carmen Johnson, Indigenous American woman raised in Prince George's County and reside in Anne Arundel County. I am also the Executive Director of Helping Ourselves to Transform. We helped draft this legislation with 28 interns from Maryland and DC. Winston Churchill once said, in wartime, truth is so precious that it should always be attended by a bodyguard of lies. What Churchill understood is that truth is powerful, and power makes people uncomfortable. Truth is often delayed, distorted, or hidden, not because it's weak, but because it disrupts systems that rely on concise rather than accuracy. In courtrooms, survivors of abuse experience this every day. Indigenous Black women and other marginalized individuals are impacted most. Look at the number of Indigenous Black women sitting at MCIW and the length of time they are serving. I've spoken with over 150 incarcerated Black and white women who said their abuse was ignored and their trauma dismissed. Abuse isn't always visible, but it leaves records that are often excluded. This way is not justice. The PATH Act doesn't excuse crime or weaken the courts. It simply ensures evidence of abuse can be considered at sentencing. Churchill never meant for truth to be buried forever. A bodyguard is meant to protect the truth, not imprison it. When protection becomes permanent concealment, truth no longer serves justice. It serves injustice. The PATH Act restores balance. Most importantly, it gives judges information, not instructions. It allows sentencing to reflect in reality, a stripped down snapshot that ignores lived truth. Justice cannot exist without truth, and truth cannot serve justice if it is never allowed into the courtroom. For this reason, I respectfully urge a favorable report on the PATH Act, and thank you, Senator Henson, for sponsoring this bill. Thank you.
Excellent. All right. Mr. Chamber, you're up next.
Hello, everybody. Good afternoon, Mr. Chairman and Vice President Chairman, and also the Judicial Committee. I am Nasir Mathis Chambers, a public policy and political science student at St. Mary's College of Maryland, and I'm speaking in support of Senate Bill 138, or as known as the PATH Act. In addition to my studies, I serve as an intern with Helping Ourselves to Transform, led by the Honorable Dr. Carmen Johnson. As Dr. Johnson's mentee for many years, I've seen how trauma, primarily domestic violence, creates lifelong harm. Before her incarceration, Dr. Johnson survived physical and financial and psychological abuse from her former fiance and business partner that went unrecognized and unconsidered during her trial. The trauma later was compounded by the legal system and the abuse she faced while inside the correctional facility. What is most profound to me, however, is that despite the system's failure to support her, she continues to fight for the rights of cisgendered and transgendered women. Her story, however, reflects a painful reality. Our system is filled with individuals, including Black, Brown, and indigenous survivors whose experiences are often dismissed or excluded at sentencing. Many, unfortunately, remain silent out of fear or coercion or protection of their abusers versus their own safety and peace. But even when they do speak up, Maryland's current legal framework hinders them from presenting evidence of abuse in a way that meaningfully informs their sentences. This exposes a serious gap in trauma-informed understanding and in the recognition of how abuse can shape a person's decisions, survival responses, and an involvement in the legal system. The current consequences are profound. A person's life, safety, and future can be determined without the court ever fully hearing or considering the harm that they endured. By passing this bill, Maryland has a real opportunity to strengthen the fairness of our justice system and ensure that survivors receive trauma-informed responses, considerations, and access to the services and protections they deserve. I would also like to personally thank Senator Shanika Henson, and I respectfully urge a favorable support and vote on this bill. Thank you.
Excellent. Thank you very much, Mr. Chambers. All right,
Thank
now
you.
we'll move on to Mr. Adams.
Good afternoon, Mr. Chair and members of the committee, Senator Henson. My name is Charles Adams. I'm here on behalf of Bowie State University Prison Education Program and the Institute for Restorative Justice and Practices to voice strong support for the PATH Act. At its core, the PATH Act addresses a painful truth. Survivors of domestic violence are too often drawn into the criminal legal system in ways that ignore coercion, trauma, and survival. The research is unequivocal about how common victimization among justice-involved women, especially women of color. In a national report on women in jail, 86% reported lifetime sexual violence, 77% report partner violence, and 60% report caregiver violence. These experiences are not simply part of someone's past. They can shape the pathway to arrest and incarceration. The Bureau of Justice Statistics analysis found that women in state prison who report prior abuse were more likely to be serving time for a violent offense. This is exactly why courts need a structured, trauma-informed way to consider domestic violence as a meaningful factor when determining accountability and sentencing. It is not simply the past, but we understand that the past impacts our current as well as future behavior. And we need to address the underlying issues that many of our women of color that are involved in the criminal legal system are dealing with. And this act addresses those concerns. The PATH Act is not about excusing harm. It's about getting the facts right, recognizing coercion, trauma, and survival responses so that sentencing decisions are proportional, individualized, and grounded in reality. It gives justice system a responsible pathway to distinguish between predatory conduct and conduct that is deeply connected to abuse. Thank you for this opportunity to voice my support for the PATH Act.
Excellent. Thank you very much. All right, we'll now hear from Sakalia Saki.
Sakila Saki. It's okay.
Saki, yep.
It's okay. Good afternoon, Senator Will Smith, Vice Chair, and members of the Judicial Committee. My name is Sakila Saki, and I am a resident of Hyattsville, Maryland. I am a sociology major at Bowie State University and a future social worker committed to trauma-informed care and community healing. Because I have learned that behavior does not begin in courtroom, it begins in someone's life story. I have been an intern with Helping Ourselves to Transform since 2025 under the guidance of Dr. Carmen Johnson. I'm also a creator and a collaborator on the PATH Act, and I currently serve as the lead intern and executive assistant with Helping Ourselves to Transform. I am here today in strong support of the PATH Act. In my work, I have met people whose first experience with the justice system was not about crime. It was about survival and lives shaped by trauma, unaddressed mental health needs, and cycles of addiction. Too often, especially in Black and Brown community, that survivor is met with system of blame instead of system of support. What I learned is this: when pain is treated like a crime, it does not disappear, it deepens. The PATH Act matters because it allows courts to see the full human story behind a case, not just the worst moment in it. It does not remove accountability, it reshapes it. So it leads of healing instead of lifelong harm. I have seen what happens when people are met with support instead of rejection. Families reunite, stability replace shame. This is what happened when policy matches real life. Passing the PACT Act is about more than reform. It is about who we choose to be as a state, one that needs to react after harm or ones that believe in healing, accountability, and second chances. On behalf of survivors, family, and community across this state, I urge a favorable report on SB 0138. The PACT Act does not weaken justice, it deepens it. And it is the path Maryland must take. Thank you again. Once again, my name is Tequila Saki.
Thank you very much, Ms. Saki. All right. Gwen and Levy, you're up. Gwen, welcome.
Yes. Good afternoon, Senate Chair Will Smith and Senate Co-Chair Wall Street and members of the committee. My name is Gwendolyn Levi, and I'm here to testify in support of the PACT Act, SB 138. As one who served 9 years of a 400-month federal sentence at MCIW, I was released after serving 16 years in 2020 on compassionate release by my judge. During that time, I was able to see and talk to many women like myself I was able to talk to many women like myself who stated that even though their case didn't involve domestic violence had, was, and still is a factor in their behavior. Please read my written submitted testimony. We're asking that you not allow the courts to continue to address our criminal behavior without addressing the failure of our community to address the root cause of that behavior. Maryland has a chance to continue its path of criminal justice reform by passing the PACT Act so that the trauma that continues to affect our actions can be recognized by our courts. I urge you to pass a favorable on SB 138. I want to thank Senator Smith and Henson, along with the Helping Ourselves to Transform organization, for bringing this issue to the forefront. Again, thank you, and please favorably support this bill.
Excellent. Thank you very much. All right, let's go with Dr. Muhammad.
Good afternoon. Excuse me, Chairman. Mr. Chairman, member of the Judicial Assembly. Thank you for this opportunity to share my testimony. I am Dr. Mildred Muhammad, award-winning global keynote speaker, certified domestic violence advocate, and survivor of long-term coercive abuse. I'm also the former spouse of the individual later known publicly as the DC Sniper. I'm here in support of the PACT Act because it addresses a critical gap in how our justice system understands domestic violence, coercion, and accountability. Domestic violence and abuse is not only physical. It includes coercive control, threats, intimidation, isolation, economic abuse, and psychological domination. These tactics strip victims of autonomy and force decisions rooted in survival. When courts cannot consider that context, sentencing becomes disconnected from the truth and from public safety. Before the 2002 shootings, I repeatedly sought help from law enforcement and the FBI after my children were taken out of the country by their father instead of being returned from a scheduled visitation. Custodial interference is a first-degree felony and treated as kidnapping, yet no action was taken even though I had a lifetime restraining order in place. I told authorities I was hiding because he said, "You have become my enemy, and as my enemy, I will kill you." Instead of protection, I was told investigators wanted to place me in the middle of a parking lot and use me as a decoy to draw him out. I refused because no one would have known where the bullet would have come from. At the time, the public was told to look for 2 white suspects in a white box truck. The reality was 1 Black adult male and 1 Black boy traveling in a Chevrolet Caprice. That misdirection mattered. It diverted attention from my circumstance as the intended target. The PATH Act does not excuse crime. It does not remove accountability. It gives court the authority to consider credible evidence that domestic violence was a significant contribution. Please pass this act to help other victims and survivors.
All right, thank you very much, Dr. Mohammed. We'll now move on to Mr. Jenkins.
Thank you. Good afternoon, Senator Smith, Vice Chair, Senator Henson, and the Judicial Committee. My name is Nasir Ali Jenkins, and I am writing in full support of the PATH Act. Since 2025, I've served as a college intern with Helping Ourselves to Transform. I'm a part of an organization committed to trauma-informed advocacy, community healing, and justice-centered reform. I'm a recent graduate of Bowie State University with a Bachelor's of Science in Criminal Justice with a focus in social justice. This degree and education have prepared me for advanced legal and policy work in social services. Through my work with Helping Ourselves to Transform, I have seen how untreated trauma, mental health needs, and a lack of appropriate intervention, particularly in Black, Brown, and queer communities, may push individuals deeper into the criminal legal system rather than toward healing. Many justice-involved individuals are survivors of violence, poverty, substance abuse disorders, and systemic inequities, yet the current system too often responds with punishment instead of care, which perpetuates cycle of harm. An additional demographic that is often overlooked and underreported are men who are usually too scared or embarrassed to come forward and report said abuse. The PATH Act acknowledges that accountability and healing can coexist. It provides justice-involved individuals access to trauma-informed care, behavioral health support, and rehabilitative services, which prioritizes prevention, restoration, and long-term public safety over incarceration. My experience working with survivors and justice-impacted individuals shows that addressing root causes such as trauma, addiction, and untreated mental illness significantly reduces future system involvement. Passing the PATH Act is not only a matter of justice reform, but also of public health, racial equity, and fiscal responsibility. Trauma-informed alternatives reduce recidivism, strengthen families, and lower long-term costs while affirming the dignity and humanity of those deserving meaningful support. On behalf of survivors, families, and community members, I strongly urge a favorable report and decision on Senate Bill 138. Thank you.
Excellent. Thank you very much. All right, we're going to go on to Ms. Watts of the Lydia variety.
Good afternoon, Chairman Smith and the other Judicial Proceedings Committee members. Thank you for this opportunity to testify in support of SB 138. My name is Lydia Watts, and I'm the inaugural Executive Director of the Rohr Center at the University of Maryland, Baltimore. Rohr is a one-stop service center providing legal, mental health, and care coordination to crime survivors, an approach that research consistently shows improves outcomes for individuals with complex needs. I have practiced law for more than 29 years, largely in civil and criminal cases involving victims of serious violence, and I have worked directly with survivors for 7 years before law school. My perspective is shaped by long-term frontline experience, not theory. In those many years of working alongside survivors, nearly all of them that I either represented or got to know in some other context had not contacted law enforcement, or if they had, the results of doing so were at best very challenging. The reasons many did not call the police were varied and practical. Concerns about safety, immigration consequences, escalation, or simply the belief that reporting would not meaningfully improve their situation. Rohr serves individuals who, for all those many reasons, fall outside of traditional response pathways. It is important to recognize that law enforcement plays a critical role in investigation and accountability. At the same time, that role is not designed to address the full scope of survivors' needs, particularly long-term safety, stability, and recovery. When those needs go unmet, survivors may remain, and often do remain, in dangerous situations or make choices that later expose them to criminal liability. I recently worked on a case involving a pregnant survivor charged with a felony after defending herself following years of documented abuse. I urge a favorable report for SB 183.
All right, Ms. Watts. Kimberly.
Thank you. My name is Kimber Watts. I'm the
head of the Forensic Mental Health Division of the Office of the Public Defender. Thank you, Chair Smith and members of the committee for hearing us today. I will be brief because all of the other panelists have really been amazing. What I will say is that all too often, as somebody who's represented many women who have been the victims of domestic violence, while we can tell a judge that and try and make that a meaningful thing at sentencing, they aren't required to consider it. They can, they don't have to. And this bill would require them to at least explain the decisions that they make and say on the record the reasons for those decisions as it regards domestic violence. I think one of the important things to contextualize and understand is that, while sentencing guidelines in Maryland aren't mandatory, they do have to fill them out. And that includes the use of departure codes. Notably, whether the defendant was a victim of domestic violence or how that impacted the crime itself is not among those departure codes. The Maryland Office of the Public Defender supports this bill with the amendments proposed in our written testimony to expand it to a wider variety of people, and because it recognizes the inherent humanity in our clients who've been the victims of domestic violence and allows for just and compassionate sentencing in light of their particular circumstances. Thank you.
Excellent. Thank you very much, Ms. Watts. We'll now go to Greta Gardner. Ms. Gardner, you're up.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. Thank you for your leadership, Senator Henson. My name is Greta Gardner, Chief Legal and Program Officer, National Center on Violence Against Women in the Black Community. The PATH Act is not about redundancy. It's about accuracy, fairness, and public safety. This bill fixes a gap in our justice system. The PATH Act refines procedural fairness by allowing courts to consider the complex dynamic of domestic violence when it actually matters, specifically for survivors. The current departure factors for sentencing guidelines are not specific to domestic violence. The court can consider mitigating circumstances, but the PATH Act says the court must treat domestic violence as a mitigating factor in sentencing and may depart. Maryland already accepts this logic everywhere else. We account for context in veterans court, drug court, juvenile court, and other problem-solving courts because circumstances matter.
Yes, it is.
We recognize PTSD, addiction, and adolescent brain development as relevant to culpability. Survivors of domestic violence who endure documented patterns of control and violence deserve the same common sense evaluation. This bill allows judges to weigh the totality of circumstances before imposing life-altering punishment that has generational consequences for housing, employment, education, and basic needs. This approach works and makes a statement. New York's Domestic Violence Survivors Justice Act has resulted in dozens of resentencings without undermining accountability or public safety. What it has done is prevent the state from compounding violence with injustice. There is evidence that this policy works. Inaction denies a vital remedy for survivors who are waiting now. Maryland must intentionally address crime accurately, not generally or blindly. We urge a favorable report.
All right, thank you all very much. We have a question from Senator James.
Yes, and thank the sponsors so much for this. And I'm not as familiar as you are, so I appreciate really all the work you and the group did. But I am just, perhaps you had a chance to see the States Attorneys Association's sort of informational testimony. And before I saw that, I kept thinking, I didn't know we weren't allowed to put in mitigating circumstances. I didn't know we weren't allowed to discuss domestic violence. And so when I finally read this, I realized, no, that is what happens, and you can do that. So just really briefly, and then you can follow up with me. I'm trying to figure out why this approach, given the notation by the state's attorney that now the victim defendant will have to meet this preponderance, of the evidence, which is not required in other circumstances. You might tell me it's the trade-off to get sort of a certainty of the mitigation. And then probably this is well documented, but I was not familiar with some language in the bill, and I apologize real quick. Again, you can follow up with me. I think it had to do with sort of the court finds that it was a significant contributing factor, and what I guess they'll bring in experts or additional testimony to just determine the court's qualified to do that. So here's my last question. So this is a very serious set of circumstances. We also have very serious circumstances involving child abuse that may go on for your entire life, but is perhaps not under this. And then we have significantly evolved understanding of mental health, mental illness, mental conditions. So we have a lot of areas in which we are evolving and understanding the circumstance of people's lives and how that ought to be not ever an excuse, but certainly a conversation and a deeply understood context for a case that comes before a court. So long question, maybe we can do it offline, but just wondering about how if we pass something like this but didn't recognize and do the same for those other circumstances, how might that affect the court? And or should we do something a little more globally to recognize all of this? And then finally, I guess just to addressing some of the state's attorneys' other issues about maybe there's an alternative way. I'm really long question, but maybe just follow up with me later. All right, thank you.
Thanks. Ms. Watts, if your answer is responsive to Senator's question, go ahead.
Oh, yeah, sure.
Thank you, Chairman. Yes, it is, in fact, and you are correct that the prosecutors can take a history of domestic violence into consideration, but as you noted, it is not mandated. I will also note that there's no currently post-conviction relief available for many of these criminalized survivors because the Second Chance Act, very laudable, great piece of legislation, was really aimed at juveniles and recognizing the unique nature of being a young person who is involved in the criminal justice system. Most domestic violence victims who are criminalized survivors that are now imprisoned do not fall into that age range. And so there is no currently any post-conviction relief for a survivor to raise that history. I will also note that though I ran out of time in my testimony, that the survivor I met recently, her history of domestic violence was not uncovered until very late in the case, really due to very tight resource constraints. We know the Office of Public Defender, they have many, many cases. And so that history, even though she kept bringing it up, wasn't taken into consideration because, again, because of those resource constraints. But if it was mandatory that be screened or that it be brought up in discussions of mitigation, it really is about accurate fact-finding, proportional accountability, and preventing future harm.
Excellent. Thank you very much. All right. Further questions from the committee? All right. Seeing no further questions, thank you all very much. With that, looks like that will conclude the testimony and the hearing for what bill is that? 138. Senate Bill 138. There we go. All right. We are now on to Senate Bill 230, Senator West, and then we'll follow it up with Senate Bill 162.
Last two bills of the day, and both of these bills are to fix anomalies in the existing law. So they're pretty simple. Let me present Senate Bill 230 first. The purpose of this bill is to fix an anomaly in Maryland's criminal statutes dealing with sexual crimes. There are different degrees of sexual crimes. Rape in the second degree is the act of rape alone. Rape in the first degree is rape plus an aggravating factor, including weapons, threats of death, suffocation, multiple assailants, and the like. Criminal law section 3-303, that's where it comes from. Another aggravating factor in rape in the first degree is burglary. in the first, second, or third degree. So if someone enters a house to burglarize the house, and in the process of burglarizing the house encounters a woman and rapes her, that's rape in the first degree. It's rape plus the aggravating factor of burglary. Similarly, there are 2 degrees of sex offenses for crimes involving the unconsented touching of intimate areas. 4th degree sexual offense includes the act of touching without consent alone. 3rd degree sexual offense includes the same conduct plus an aggravating factor. And just as in the case of 1st degree rape, these aggravating factors are weapons, threat of death, suffocation, multiple assailants, and the like. However, missing from the list of aggravating factors in 3rd degree sexual offenses is burglary. So if a person enters a house in order to commit burglary, encounters a woman and rapes her, that's an aggravating factor which would take the rape from 2nd degree rape to 1st degree rape. However, if the person enters the house in order to burglarize the house and encounters a woman and molests her, but without raping her, sexually touches her, that burglary is not currently an aggravating factor. So that a non-consensual touching would remain 4th degree rather than 3rd degree. This omission is inexplicable. There is no obvious reason why the commission of a sex crime in connection with a burglary will elevate a rape to 1st degree rape, but does not elevate an unconsented touching to 3rd degree offense. So this bill simply rectifies this situation and establishes in law that engaging in such behavior constitutes a sexual offense in the 3rd degree. The bill further alters the definitions of Tier 1, 2, and 3 sex offenders to apply to those who have committed these or certain acts in the 3rd degree. So I appreciate the committee's time and consideration of this bill, which, as I say, merely corrects this anomaly in the existing law. And I'm pleased that Lisa Jordan, Stacey Reed, and Joyce King are here to testify in favor of the bill, and then we'll take questions.
All right, thank you very much, Senator. Let's hear from, I see Ms. Jordan here, so let's, Ms. Jordan's up first, then we'll hear from Ms. Reed.
Thank you, Chairman Smith, Mr. Vice Chair, members of the committee. I'm Lisa Jordan at the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 230. Senator West did really an excellent job explaining this bill. It's really got 2 aspects in my mind. One is simply the logical inconsistency in our law, where for rape, being raped during a burglary is considered a more serious offense, but this is not the case when we move between 4th degree and 3rd degree. So there's a list of aggravating factors that moves 2nd degree rape to 1st degree rape, the same list for 4th degree to 3rd degree, except burglaries missing. Senator West did a great job explaining that, so I'm not going to repeat it, but I want to say that it's not just logic. Like, that's not the reason to fix the bill. It's a reason. It's that when somebody invades this space that you think is private and that you think you're safe and protected, that really shatters your sense of security. But then when they also sexually assault you during that burglary, the harm is just so much more. And our laws need to have, varying degrees. And this is a very serious crime. And so we should treat it in a very serious way. And the last thing I want to say is that this happens. Burglars break in, and in the course of the break-in, they fondle the victims they find there. And, this is a thing. I've talked to too many people, and I know Ms. Reed is going to tell you some specific stories. And it shatters their sense of security to be the victim of a burglary. And then it affects them for life when they are fondled by that burglar. We need to treat this seriously. And Senate Bill 230 would treat this harmful, creepy, emotionally scarring sexual offense with the seriousness that it deserves. So we urge a favorable report.
All right, thanks a lot. Ms. Reed, you're up. Welcome.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee.
My name is Stacy Reed. I'm an assistant state's attorney for Baltimore City. I'm currently assigned to the Special Victims Unit, and I am here to testify in support of Senate Bill 230. To explain my support, I would like to talk about a case that we had in 2022. On October 20th of 2022, the Baltimore Police Department responded to an apartment building, met with a young woman who stated that at about 3 o'clock in the morning, she awoke to a strange man standing in her bedroom, no pants on, masturbating in front of her. She didn't know the man. She certainly hadn't let him into her apartment, and was, of course, traumatized by the experience. The police found the individual. We were able to prosecute him. However, the only sex crime available to us to prosecute was the 4th-degree sex offense. It's a misdemeanor, punishable by up to a year. That may be appropriate for someone touching someone in an intimate area in a bar, maybe even somebody masturbating in front of you on a public bus, but this is something different. Common sense tells us that this is something different. As Ms. Jordan stated, this individual entered this woman's home, violated her privacy, came at her in a place where she felt that she should be safe. And the law didn't allow us to address it in that way. I would note that the police responded to 3 additional calls to this apartment that same night. 3 additional victims came forward to say that this individual had broken into their homes. One woman found him in her closet. One woman found him standing in her room without any pants on, completely naked from the waist down. And yet another woke up with him in her bed, laying next to her completely naked. He was engaging in predatory behavior. We weren't allowed to treat him in that way. And this failure of the law needs to be fixed, which is why I support a favorable report on this bill from this body. Thank you.
I think that's it. I don't see Joyce King in the virtual room, and I know she was here physically earlier, so I think that will conclude the testimony, but are there questions? Senator James.
Senator West, thank you very, very much for bringing this bill. I think you're getting ahead of that great commission that's going to hopefully, recodify our criminal code and correct a lot of anomalies. But very briefly, I'm curious how you caught this, or maybe your panelists and state attorneys caught this.
Actually, I didn't catch it.
Okay,
Ms. Jordan brought it to me. I think she told me that she had brought this to the General Assembly over 10 years ago. Was it? A long time ago. Okay. And it didn't move. And she's had other fish to fry in the meantime. So she took a look at what she'd not accomplished many years ago and said, well, let's do it this year.
Then, Mr. Jordan, if you don't, yeah. Do you have a sense that this was an anomaly, or was this back in the day more of an underappreciation? Because we get it. I get it as a woman. I get it, right? Shattering, right? And the way the law is now would absolutely not address or understand the deeply shattering aspect of this. But just briefly, do you think it was sort of a hangover from, an insensitivity to this, or was it truly because we do have an odd criminal code that, we need to address that as well? Just very briefly, if you happen to know.
Yeah, thank you for the question, Senator James. My sense at the time was that there was a worry that it was very easy to lie about sexual contact, and therefore they were treating it differently in these burglary cases. Really? As you know, leadership was very different then, and we are very appreciative of Chair Smith and Chair Bartlett.
Well, we certainly know how many women like to lie about having somebody burglarize you and do something like that. It's really one of our favorite things to do. Okay, that doesn't make any sense, but I thank you all, too, for bringing it to our attention. Thank you, Mr. Chairman.
Thank you very much. Senator West, did you have an opportunity to review the public defender's testimony?
I did not. I saw it. I arrived late because I was excavating my house from the ice. I saw there was testimony. I sent it to Ms. Jordan. She promised to take a look at it. So if you have questions about that, I would ask you to direct them to Ms. Jordan.
All right. So two questions. Ms. Jordan. One, it's the initial second paragraph. It states that Senate Bill 230 is unnecessary because the conduct it targets is already fully criminalized under existing Maryland law. Would you mind speaking to that?
Yes, thank you for that, Senator. The second sentence of that paragraph says third-degree sexual offense already prohibits non-consensual sexual conduct and carries a felony. That's actually not quite complete. To have the third-degree sexual offense, you have to have the non-consensual sexual conduct plus an aggravating factor. That's the whole point of this bill. So it's true that it's punishable as a 10-year felony if it also involves an aggravating factor. Those are employing a dangerous weapon, a physical object that looks like a weapon, suffocation, strangulation, disfigurement, serious physical injury, threatening to place the victim in fear of those things. So all of those are seen as moving the non-consensual sexual contact from fourth degree to third degree. What we're saying is that burglary needs to be added to this list. It's true that people can't touch you in intimate areas without your consent, but without an aggravating factor, it's not a felony. It's a 1-year misdemeanor. And so it's a very different thing. And I think as Ms. Reed really explained, it's very different. Someone, masturbating on the street and, being near you and sexual contact in that context is terrible and a crime. But someone coming into your home, breaking in and burglarizing, that should be treated more seriously. And that's really what the bill does. So I don't dispute that it's already a crime. I do dispute their assertion that this is already a felony punishable by 10 years.
Okay. And the second question goes to the next paragraph, which talks about the language on page 2, line 14, in connection with. Would you mind just to speak to that a little bit and what it is that you're intending that to mean?
Yes, thank you very much, Senator. If you look at our current law, 3303 is rape in the first degree. And so that's where we have the aggravating factors for the sex crime of rape. And this exact same language is used there. So the in connection with is already in our statute. It's already used in 3303. And to my knowledge, it has not been vague or problematic in that context. I don't think it would be vague or problematic here. In fact, it would be helpful to have it consistent in both sections of the law.
Do you know if it's been defined in case law?
I don't know, but I can certainly find out and look at that. And I would suggest if you feel like it's vague or inconsistent, that it be changed in both places.
Is the Public Defender's Office going to be testifying? All right. Thank you.
Thank you.
All right, further questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 230. We'll now move on to the last bill of the day, 162. Senator West.
Thank you, Mr. Chair. So this bill relates to a enactment that was certainly critical in my career here in the General Assembly, which was the Juvenile Restoration Act. I can well recall standing on the floor. The chair was there with me that night after the governor had vetoed my bill, and standing there urging the body to override Governor Hogan's veto of the Juvenile Restoration Act. So I've had a proprietary feeling about this ever since. So today's bill is to fix an anomaly in the Juvenile Restoration Act. At the peril of repeating something that I know Senator James is well familiar with, but maybe some other members of the committee aren't as familiar. Let me just quickly remind you what the Juvenile Restoration Act is about. So it was passed in 2021. The act allows people who have been incarcerated for at least 20 years for a crime that they committed when they were under 18 years of age to file a motion with the court that sentenced them for reduction of the sentence. The state's attorney can appear at the hearing and introduce evidence and argue against the sentence reduction. After the hearing, the law permits the court to reduce the sentence only if it determines, one, that the individual is no longer a threat to society, and two, if the court determines that the interests of justice would be served by reducing the sentence. So that brings us up to last year when we passed the Second Look Act, which extended the group of convicted persons able to go back to court after 20 years to include people who committed their crimes up until they were 25 years of age. It took the 18 years of age and moved it up to 25. So at this point, anyone who committed a serious crime up until they were 25 years old and who served 20 years of incarceration may go back to the court that sentenced them and ask the court to consider reducing the remaining term of their confinement. But now here's the anomaly. When the Juvenile Restoration Act left the Senate and went over to the House 5 years ago, language crept into the bill excluding a small subset of juveniles from the Act's coverage. I'm given to understand that the reason for the exclusion was that the House Judiciary Committee leadership intended to introduce separate legislation dealing with parole reform that would have affected the excluded group. But that never happened. And the exclusionary language remained in the Act and then came back to us, and I don't think we paid an awful lot of attention to it. We simply, it was late in the session, we're pushing sine die, and we passed the bill as sent back to us from the House. So as a result of the exclusionary language, juveniles who committed crimes and were sentenced after October 1st, 2021 are not able to take advantage of the Juvenile Restoration Act. So other Maryland citizens who committed a crime under the age of 25 are able to petition for a reduction of their sentences after they've been in prison for 20 years. Nobody's been able to provide a logical reason for why this exclusion exists. And I believe there is, in fact, no logical reason for the exclusion. It just is an anomaly that happened back in 2021, and we should fix it so that everyone under the age of 25 who commits a crime and has been in jail for over 25 years, over 20 years, has the ability to come back and ask to have their sentences reconsidered under the JRA. It defies common sense for some youthful offenders to be able to proceed under the JRA while others don't have that course available to them, simply because of the inclusion of the arbitrary October 1, 2021 date in the current law. We need to eliminate this anomaly from the law, and that's why this bill's brought. So I have with me Nicola Nabel-Juris, Sarah Citroni, and Brian Cicenti, who are going to testify, and after which we will all take questions. Thank you.
Good evening, Chair Smith and members of the Judicial Proceedings Committee. My name is Nicola Nabel-Juris, and I'm the National Legal and Policy Director for the Campaign for the Fair Sentencing of Youth. The campaign is a national nonprofit that collaborates with policymakers, national and community organizations, and people directly impacted by these policies to develop solutions that keep communities safe and create opportunities for children to return to the community after rehabilitation. We want to thank Senator West for championing the Juvenile Restoration Act in 2021, and now thank him for his sponsorship of Senate Bill 162 to ensure fundamental fairness in the application of the Juvenile Restoration Act. As Senator West said, in 2021, the Juvenile Restoration Act created this mechanism for review for individuals who were under 18 at the time of their offense and contained a date restriction for individuals who were sentenced before October 1st, 2021. Last year, the Second Look Act expanded the Juvenile Restoration Act to many individuals who were between 18 and 24 at the time of their offense, but contained no date restriction. As a result, Maryland currently is in a situation where some 24-year-olds have more rights than children who are under 18.
Over the last 2 decades, the U.S. Supreme Court has repeatedly affirmed that children are different than adults for the purpose of criminal sentencing. The death penalty has been found to be unconstitutional for children under 18. Life without parole for non-homicide offenses is unconstitutional for children under 18. Mandatory life without parole is unconstitutional for children under 18. Youth must be considered at the time of sentencing. The U.S. Supreme Court has repeatedly said that children are different, but difference has always meant more protections for children under 18, not fewer. In all the states that have responded to these decisions, it is unheard of for states to give children under 18 fewer protections than individuals who are over 18. Similarly, states that have expanded second look provisions for the emerging adult population have never done so in a way that leaves behind children under 18. So Senate Bill 162 is a simple technical fix that ensures constitutional compliance and fundamental fairness for children who are in the criminal justice system in Maryland. We encourage a favorable report. Thank you.
Good afternoon. My name is Brian Ciceni. I'm here on behalf of the Maryland Office of the Public Defender. We're requesting a favorable report on Senate Bill 162. As you've heard, this bill is a technical fix to an anomaly in Criminal Procedure Article Section 8-110. That statute allows certain individuals who have served at least 20 years for an offense that occurred when they were under the age of 25 to file a motion for sentence reduction. Now, a normal benefit of legislation like this is that it gives people hope and an incentive to improve themselves and to rehabilitate. This benefits everybody. It benefits the individual, society at large, benefits the correctional officers and staff who interact with these individuals. Section 8-110 presently does that for most young adults who receive lengthy sentences, but paradoxically, not for minors. If our young adult client today receives a lengthy sentence, we can tell them, don't give up. Do your best while incarcerated, stay out of trouble, do every program you can, and a judge will take that into consideration in the future. Minors sentenced today, if you're under 18, don't have that opportunity. The sentencing date limitation deprives minors of that incentive, of that hope. The sentence date restriction was never good policy, we would submit. And it certainly is not now because it bizarrely treats the youngest offenders worse than young adults. And for these reasons, we respectfully request a favorable report. Thank you.
Begin? Chairman, Vice Chair, and members of the committee, thank you so much for the opportunity to testify today. My name is Sarah Citroni, and I'm here in strong support of SB 162. I am a direct descendant, recipient, and released under the JRA. In 1993, when I was a teenager, I was sentenced to life in prison. I stood in that courtroom and listened as the prosecuting attorney explained that if I did everything that I was supposed to do and I turned my life around, I could expect a meaningful chance for parole in about 15 to 17 years. I remember counting my age and thinking, okay, this is doable. Months after that, the presiding governor's policies changed, and he stated that life meant life and all hope disappeared. For the next 26 years, I pretty much lived with the reality that I had not really meaningful hope for release under parole. Being really young and scared and impressionable, prison can take you into two directions. It can either break you or it can force you to grow. And I chose to grow. I committed to myself every day to programming that I could access, and I did everything that I could. I created programs. I pushed hard to be a better version of myself. But I want to be clear, I'm not a unicorn. There are many people inside who have changed, who have matured, and who are truly different versions of themselves. And 20 years from now, others who are incarcerated will follow and make those same choices. In 2022, I was released under the JRA, and one of my main supporters was that same prosecutor who assured me I would have a chance. Since coming home, I've been on the right path. I work with an organization that helps individuals who are incarcerated kind of map out their reentry plans, think about next steps, and make sure they have the things they need to be successful. I work with dozens of organizations that are employed by folks just like me. In May, I'll graduate from University of Baltimore with a BA in Human Services, and I walk the campus with about 20 guys who are the same as me, returning citizens under JRA. Supporting this bill does not open the floodgates, just as the original JRA did not. Judges review decades of aspect of records, growth, their conduct, and their decisions are thoughtful, careful, and grounded in public safety. It's just a technical fix. I urge you to put a favorable report on this bill. Thank you.
Excellent. All right. Thank you very much, Senator. And for your panel, questions from the committee. Excellent. Thank you all very much.
Thanks.
All right. Is Olinda? There you go. Crystal Carpenter. Sarah Citrani. Oh, you went, sorry. Earl Young. Virtual. Anthony Mohammed. And then Teresa Darvish.
Oh, wait.
Oh, sorry, Teresa, sorry, you're in favor. My bad, you're on the next panel. My apologies, sorry. And we'll do that. Okay, go ahead.
Good afternoon, almost evening again. I am Olinda Moyd. I'm representing the Maryland Alliance for Justice Reform. We urge a favorable report on SB 162. We believe that it's a simple bill that ensures fundamental fairness. The Maryland Alliance has supported legislation that enacted providing resentencing mechanisms for individuals, the JRA and the Second Look Act. The legislation currently mandates that individuals be sentenced for the offense before October 1st, 2021. The sentencing date limitation in the statute should be repealed to achieve fairness and just sentencing opportunities for eligible individuals. The current legislation creates an unconstitutional inconsistency where individuals receive an opportunity for review only if they meet a certain date requirement. I, as a defense attorney, have represented several individuals under the Juvenile Restoration Act. I currently have Second Look clients that I'm representing as well. If I were representing two individuals who were co-defendants, Mr. A and Mr. B, and Mr. A was sentenced on September 29th, 2021, and Mr. B was sentenced on October 1st or October 2nd of 2021, Mr. A would be eligible, Mr. B would not be eligible. Maryland laws must be fair and consistent in order to build societal trust, ensure equitable treatment, provide legal certainty, and uphold respect for our criminal legal system. This bill is a common sense, straightforward, technical fix, and we ask for a favorable vote. Thank you.
Good afternoon, Mr. Chairman, Vice Chairman, our legislative sponsor, Senator West, and members of the committee. My name is Anthony Mohammed. I am a returning citizen, justice impacted individual who was also released under the Juvenile Restoration Act in September of 2022. At the age of 15, I was arrested for first-degree murder in the city of Baltimore, and I served a total of 29 years, 7 months, and 29 days on that sentence. I agree with everyone who came before me that this legislation is a technical fix, and it is my hope that this committee will not make it anything more than that. We cannot have what, in my opinion, are the two most significant pieces of criminal justice reform legislation to come out of this committee in the last decade in such blatant contradiction to each other. The Maryland Juvenile Restoration Act and the Maryland Second Look Act. So it is my hope that this will be a technical fix, because every member of this committee knows, every parent in the room knows that children make bad decisions. And it is unthinkable that we will hold children accountable for the rest of their lives for the decisions that they make as children. All of the science, all of the research, all of the data shows that the brains of children are not even developed enough So it is unthinkable that we will hold them accountable for the rest of their lives for those decisions. And on behalf of dozens of other JRA releases who are doing phenomenal work in their community all throughout the state of Maryland, we urge a favorable report on this bill. Thank you.
Good afternoon, Chair Smith, Vice Chair Wall-Striker, and members of this committee. I want to thank you for the opportunity to submit testimony in support of SB 162. My name is Crystal Carpenter, and I serve as the Chief Operating Officer for this campaign for the fair sentencing of youth. And I have the honor of leading the National Family Network, which is a network or a collective of family members and loved ones impacted by youth violence that includes survivors of youth crime. This legislation is a common sense fix, and I want to begin by thanking this committee for recognizing the issues, and specifically Senator West. This is not a bill that should wait. Every moment this oversight goes unaddressed leaves room for inequities to persist, and it is important for the courts to know that this body is actively correcting an unintended consequence of prior legislative action. SB 162 builds on a strong bipartisan foundation. In 2021, with the Juvenile Restoration Act, this body moved forward with major youth justice reform led by Senator Chris West and former Delegate Jazz Lewis from across the aisle. Alongside them, we had members across the state and across the nation who supported this effort. Those who were here at that time may recall the extraordinary breadth of support from state's attorneys to judges, survivors of violence, victims' family members. National voices all came together to urge passage of the Juvenile Restoration Act. That support reflected not only shared values, but a shared understanding that the racial and legal inequities tied to extreme youth sentencing demanded urgent action. SB 162 honors that history and strengthens the integrity of the reforms this General Assembly has already championed. By clarifying and fixing this issue now, the committee reaffirms its commitment to fairness, equity, and thoughtful implementation, and sends a clear message that Maryland does not ignore problems once they are identified. For these reasons, I respectively urge a favorable report on SB 162. Thank you.
All right, we'll hear from our virtual panelists. Let's start off with Mr. Young.
Good afternoon, Chairman Smith, Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity to give my strong support for Senate Bill 162. I'm a Maryland resident, a returning citizen who served nearly 35 years in Maryland prisons before former Governor Larry Hogan commuted my life sentence to 49 years. Because of diminution credits, I was allowed to come home 2019 prior to the passage of the JRA. I entered the prison in 1984 at the age of 17, and at that time I had hope. Hope that I would work hard, stayed out of trouble, focused on rehabilitation, that I could one day be paroled after serving approximately 15 years. That hope was severely damaged in 1995 when former Governor Paris Glendenning implemented Life Means Life policy. Overnight, it became clear that no matter how hard I worked or what good I did, it didn't matter. Despite that, I continued to do good. I earned my GED, pursued college, and maintained trusted preferred work assignments. Many others started to languish. They started to fall off. They started to lose hope. When hope is removed, people give up. They lose motivation, purpose, and a reason to live. Hopelessness creates instability within prisons, requiring higher security, making institutions more dangerous for everyone, including people, incarcerated individuals, and staff. Since returning home, I have committed myself to doing the same thing in the beginning. I'm a mentor inside of Baltimore City Public Schools. I now serve as a supervisor, hiring and overseeing individuals who mentor young people. I work with the Mayor's Office of African American Male Engagement as a credible messenger and participate in group violence reduction strategy as a community referral. With my lived experience, I implore the committee to vote favorable for Senate Bill 162. Thank you.
Thank you very much, Mr. Young. All right, Mr. Pittman, you're up next.
All right. Thank you and good afternoon, Chairman Smith, Vice Chair, and all other members of the committee. My name is Bobby Pittman, and at 17 years old, I was sentenced to life plus 15 years in prison for felony murder. While incarcerated, I made a decision. I was going to change. I took every program that was available to me, either educational, personal development, counseling, anything. And in those programs, I became a leader, a mentor, I facilitated groups, and I worked to create a positive environment in a system that wasn't designed for growth. While there, I joined the University of Baltimore Second Chance College program, and I wound up receiving my degree in human services, my bachelor's degree in human service, not just to check a box, but I wanted to help the people that come from the same type of circumstances I come from. And after the release, I wound up getting a job with the Second Chance program, and I go back into the same prison that I was housed in for 23 years. And right now, I'm the founder of a nonprofit, bully intervention teams, where we focus on prevention, accountability, and community healing. And I'm pursuing my master's degree in social entrepreneurship. This is what rehabilitation looked like. Under current law, access to resentencing can depend on time and not transformation. A young person sentenced before 2021 may have access to review, while somebody sentenced after 2021 at the same age for the same conduct may not. This is not justice. Youth do not change based on the date on the calendar. Growth, accountability, and redemption are not time-stamped. I'm living proof that people sentenced as juveniles can grow, change, and give back, even inside the same institution where I was confined. Our laws should reflect that truth for everyone. Thank you for allowing me to share my story, and hopefully I urged you to change this law.
Thank you very much, Mr. Pittman. Questions from the committee? All right. With that, that'll end the testimony in the testimony for the proponents of the bill. We do have one person sign up in opposition, Ms. Darvish. Come on up.
Good afternoon, everyone, and thank you for giving me 2 minutes to speak to you. My name is Teresa Darvish. I'm a lifetime resident of Maryland and voter. 1,496 days ago, my son, my only child, was brutally, senselessly murdered in Montgomery County for money. What you read about stages of grief and everything, shock, yes, I'm over the shock. It's been 1,496 days. I visit my son every morning, including through this blizzard, and I come home every night and he's still not there. Anger, I found a way to change my anger to fight for justice. Pain is a tough one. I found a way to turn my pain and anger into a fight for justice and pain for purpose. This is why I'm here again to testify to oppose SB 162. I was against the Second Look Act expanding the JRA to age 25. If Maryland wants to save money and maybe change the prisoner's menu, lower their wages, tax the donors sending them money, repeat offenders cost Maryland much more money with new trials, public defenders, et cetera. Expanding the Second Look bill will extend more cost to taxpayers for new hearings, public defenders. The bill will immensely extend inconceivable grief and tormenting pain to the victim's family having to go back to court again and testify. Or more fair, put it on the Maryland ballot and let our 4.3 registered voters of Maryland vote on this. Circuit court judges sentenced these imprisoned felons. Those convictions were further affirmed in the Maryland's appellate court. When the Maryland appellate court affirms a conviction in a sentence, how do you justify a new circuit court judge beneath the appellate court to change a sentence and reduce it? The Second Look Act, and I asked this when I was here last year, is based on demonstrated rehabilitation and established prisoner support system while incarcerated. No one has yet to define and give the measurement of rehabilitation. What is it? I've heard last year, just one more sentence. Last year I heard from several early release people. Today we just heard from early release people and how well they did in prison and all that, and I commend them for that. Last year and today I did not hear one of them say, I'm so sorry I committed that murder. and that sorrow needs to be part of rehabilitation. And when you can send my son was born on my birthday, he was murdered on Christmas. So those two holidays for life are shot for me. But when you can send my son home from heaven, then we can talk about sending murderers home early from prison sentences. Until then, they need to stay where they belong. And at least next time you speak, say, I'm sorry. That will let me have an idea that you have some rehabilitation. Thank you for your time. Thank you for letting me extend.
Thank you. And Ms. Arbus, look, I know that this committee and the body generally has not moved in a direction that you would have preferred on certain pieces of legislation, but I do want to say thank you for your continued advocacy and for being here. I extend my condolences. Obviously, it never gets easy losing someone that's so close to you. So I just want to say thank you for continuing to show up.
Thank you. And again, my main question is, forget about, you never said, I'm sorry. How does a circuit court overrule an appellate court? How does that happen?
Yeah.
You know? But thank you all.
Thank you very much. It's great. Okay. Is someone from the state's attorneys, Carrie, signed up? Yeah. Signed up informational?
Yes.
Okay. Come on up.
Thank you so very much. Good afternoon once again. My name is Carrie Borzilleri, and I am an assistant state's attorney in the Conviction Integrity Unit of the Baltimore City State's Attorney's Office. I have been a prosecutor for approximately 12 years over the course of my career. I appreciate the opportunity to testify before you. I'm here today to provide testimony on behalf of the Baltimore City State's Attorney's Office, State's Attorney Ivan Bates, and the Maryland State's Attorneys Association. Currently, the law provides that an individual who is convicted as an adult for an offense committed as a minor is eligible to file a motion requesting a sentence reduction if the individual has served at least 20 years and was sentenced prior to October 1st, 2021. Senate Bill 162 seeks to repeal the October 1st, 2021 date limitation, which was not included in the most recent legislation that expands this law to include individuals who are between the ages of 18 and 25 when the offense was committed. We do not support or oppose Senate Bill 162, but rather we are here to advise that it would be more appropriate to revise the law to add the October 1st, 2021 limitation to all eligible cases. The main purpose of the Juvenile Reform Act was to right harsh sentencing practices that did not take into consideration the juvenile brain. Sentencing practices have evolved in recent years to ensure juveniles are not sentenced in violation of the Constitution and that their juvenile status is taken into consideration when sentences are imposed. In repealing the October 1st, 2021 date limitation, the sentences imposed by present-day judges would be automatically up for modifications in 20 years. It would be more appropriate to limit all modification requests to those sentences imposed before October 1st, 2021. Thank you for the opportunity to provide testimony today.
All right, thank you very much. Questions from the committee? Seeing none. All right, that looks like that will conclude the hearing and the testimony for Senate Bill 162. Thank you very much, thanks. And our hearings for the evening, we have two bills to vote on, so we're gonna take a 5-minute interlude. Yes. We have to reset, yeah, we're gonna push through, but take a 5-minute break. All right.